Welcome, my little couch potatoes, to the comfiest courtroom on the internet. I'm your host, Llama, and it's time for dramatic testimony, overruled objections, and absolutely unqualified opinions. So grab your snuggiest blanket, some delicious snacks, and get ready to watch court with your internet besties. This is Couch Court with Llama.
Helps if I would put myself on the stage. Good morning. Good morning, everybody. Happy Friday. It's here. We've made it. Oh, I'm so happy about that. Hope you guys are too. Hope you have good plans for this weekend. I have, of course, lots of work to do, but I'm excited about it. Excited. So happy Friday, everybody. We are on the last day of the Cardi B trial. Closings, verdict, a short press conference, and that kind of wraps it up. Good morning, Angie. Dave, good morning. I mean, I know you're saying good morning, Angie, but I'm going to say you're saying good morning to me too. Lady in Gray, good morning. Good morning. You guys, before we even get into it, I have to tell you guys something. Elbow feet is the best. Okay. He surprises me. Hello, Flash fan. Good morning. Good morning. Sorry you had to jet last night. It was very late my time, but it was nice talking to you. So Elbow Feet goes to the store yesterday and he comes home and he's like, I got you some things. And I was like, oh, okay. I love presents. And you know what he got me? Well, the first thing he got me is the Harry Potter cauldron cake creamer, you guys. It's toffee flavored and it's delicious. So I'm very excited about that because these came out a while ago and I haven't really seen them. And he got me some of those. So I was like, yes, thank you, Elbow Feet. +1 for you today, sir. Well, +2 because he got me 2. And then he didn't even know that the other day I was thinking about snacks as usual. And I was like, man, you know what? I need to start eating some healthier snacks probably. And I was like, you know what? I really want grapes. I like grapes. I don't eat a lot of grapes, but I like grapes. I don't like red grapes. Those are a waste of time. Ugh, gross. I only like the green ones or the black grapes, which are my favorite of the two. The green ones too. I like those, right? Didn't say anything to him about this. I've been thinking about grapes for like 2 days nonstop. And you know what? Not only did he bring me delicious creamer, but he brought me grapes. He brought me black grapes and green grapes. So that's my snack for today. So bonus points to Elbow Feet this week. He won. He won this week. So thoughtful. I am always talking about snacks. I don't eat as many snacks as I talk about them. But yeah, so I just had to share with that. It's delicious and I'm very happy. I just wish I would have had these earlier this week because this week has been so annoying. But, you know, it's a good way to end the week, I suppose. So, yes, we're finishing up Cardi B. Now, Monday, you're probably like, Llama, what are we going to do now? Oh, that's a good question. So last night, I found out that Chad freaking Daybell, sitting on death row in Idaho, has decided that he wants to write some letters from jail to tell his side of the story. What? And I read the first one and I'm like, oh my God, here we go again. Because I don't know if you've ever read any of Chad Daybell's like books or anything. I have, and they are embarrassing. Okay, they're so bad. It's like a 7th grader wrote them. It's not good, right? And his letter did not disappoint. There's like 5 of them out. So I think what we're going to do Monday while we're waiting to see if the trial I want to cover actually is going to happen. Monday, I think we're just going to reconvene and have some fun reading some of the Daybell, Daybell death row letters. So there's 5. I don't know how long it'll take, but whatever. We'll hang out for an hour or 2 on Monday, see what happens. Because Monday, there's also Midday Missing, and then there's our merch and membership launch party at 7 p.m. Eastern that I'm very excited about. That's all the work I have to do this weekend. And then we're waiting to see if a trial starts on Tuesday or not that I want to cover. If not, couch court, we're going to have a pretty light week next week. Like we'll meet Monday for sure to read the Daybell letters. Wednesday is the sentencing of Brooks Houck and Joseph Lawson. So we'll probably watch that on Wednesday. Now, if we have trial, I'll move that to Thursday morning, but we won't make things confusing. That's the only thing about trials, right? Is you got to like wait most of the time to see if it's ever going to happen, which is very annoying. Yes, guys, if you haven't yet, please like this video. It helps everybody know that we're live and all that jazz. Now, after today, don't forget, if you're a member, I'm going to be recording parts 6 and 7 of Devil in the Bay. Right after Couch Court today. I think at 2 is what I scheduled it for. So if you're a member, join me over for that. I still have 4, 5, 6 more episodes to go, something like that. I don't remember off the top of my head, but that's what we're going to do today over there. And then it's the weekend, baby. Yeah. Oh gosh, why did I just do an Austin Powers reference? What was that about, brain? Oh my goodness. Jeez, Llama, get it together. All right. Well, you guys, let's get into it. Let me change my little banner though real quick. Closing arguments. Oh, if you guys missed last night for True Crime and Wine Time, it was a long episode. I did warn everybody it was going to be a long episode, but it was really good. There are rants, all right? If you really want to hear Llama just pop off nonstop and it only get more and more intense, then you're probably going to want to go back and watch that show because I am irate and everybody should be, in my opinion. So if you need something to watch, go watch our part 3 of the Eitan Pates case. It will be a trial that we're probably going to cover in maybe Couch Court After Dark or something like that when it gets there. But I want the biggest light shined on this case as possible because I am very confident that I believe Pedro Hernandez is factually innocent and is being railroaded. So please go check that out and spread the word about that. Now back to our favorite judge, Ian Fusselman. I like that name. Oh, the other thing, kiddos. So yesterday, they basically read the jury instructions at the end of the day yesterday. I hope it's all right. I'm just going to like skip them again because they spend like, oh my God. They spend like a whole hour going over them again and then reading them. And it's pretty much the same. And both the plaintiff and defense go over jury instructions in their closing. So like we would just be hearing like redundant information and it's too early for that. It's too early. Cat Talk with Cardi B. Hey, if she ever starts a podcast, that's a good name for a podcast. All right. So first up is the plaintiff's closing argument, which, by the way, they freaking do like hour-long closing arguments. And I'm like, how do you even talk about any of this for an hour? There's not even that much to say. But they do, apparently. I don't understand it. But we'll see what the lovely plaintiff lawyer, whose name I still have not learned, we'll see what he has to say, shall we? All right, let me get closed captioning. There we go. You go up here. Thank you. All right, let's get started, friends.
Sides will be giving our closing argument, basically a summation of everything you've heard, just so you can jot down things, take notes if you feel comfortable.
Okay.
So you all heard all of the evidence in this case, and the distinction between a civil case and a criminal case are different. And what that means is in a civil case, our proof, what has to be in the box, is greater than 50%. Touch more than 50%, maybe a featherweight more than 50%. 51%. It's not 100%. The standard is a little bit more than 50%. In this case, you've heard lots and lots of testimony. We've had the plaintiff who's testified. We've had the plaintiff's mother who's testified. We've had the plaintiff's grandmother who's testified. Those three witnesses explained their recollection about the scar. There was testimony that the scar,
that's crazy when you think about it, isn't it?
Came from this incident. That's a very, very important fact. There's really nothing to contradict that. If anything,
that we didn't see.
Our expert witness, Dr. Mulliken, you remember he came to court. He's a very well-respected doctor that specializes in plastic surgery. And
Agreed.
his testimony was that,
I'm going to pause this for a
his
second,
opinion,
because I'm going to go on a little Llama rant. I agree, Lady and Great. And you know why? I feel like the burden of proof here, like it needs to be higher, because civil suit, while you don't necessarily go to jail, it can like wreck your whole life, your whole future. If you end up owing a bunch of money, or you're owed a bunch of money that you never get. I don't know. The whole more than half thing really kind of bothers me. I'm not saying we need like beyond a reasonable doubt, but I don't know how I feel about those stats. I mean, again, you're talking about, I mean, most of the time, sure, it's like companies and organizations that are in lawsuits or whatever, but you know, it's crazy. It's crazy to me. It seems like it should be at least higher than 50%, but I don't know. I don't understand civil law, to be honest with you, and torts and all that. It's something else. Anyway, sorry, I didn't mean to pause that, but I wanted to rant a little bit. I guess I still got some of that ranty energy me still from last night.
expert.
All right, this feels almost illegal.
Hold on. I forgot to log into the right account. Uno momento. Almost had it together today, friends. It's okay. There we go. Little switcheroo. Oh, and then it lost our spot. So that's great. Love that for us. All right. Let's try this again. And then I think tonight over on Miss Shorty's, I think they're watching this trial too tonight. I don't know. I haven't checked. But she's usually live after I'm done with my members only. So if you need something to watch afterwards today, always go over there and see what she has to say about this, because I'm sure it's great. We are professionals. I do have rant fever. Okay. Back to this guy.
Skin color, it does not show well in photos. The cut that was on the face does not show up as well. So you may have to really look at it deeper than just had it been someone else. Okay. The other thing that I wanted to highlight is I really just don't understand. The defendant came here, used all of this foul language. This is a court of law. You cannot speak this way in a court. I have never seen this before. And for her to use all of those words, F word, B word, all these different words, it's a disrespect to us. It's a disrespect to the judge. It's disrespect to this courthouse. You cannot come to court and say these kind of words. It's just disrespectful. And just because Miss Almanzar, also known as Cardi B, is a celebrity, doesn't mean that she could just say and do whatever she wants and attack people. Okay, if you recall, just to give you a little bit of background about Miss Ellis. When she was 19 years old, she moved out of her house. She went to college. She's a college graduate. She has a bachelor's. She went on to become a security guard for 4 years, from 2014 to 2018. She did whatever she needed to do to become a licensed security guard. And she did that job. And when this incident happened in 2018, that was cut off. She lost her future in security work. in something further,
I
whether
do like
it's
her hair.
FBI, police, attorney, whatever she wanted to do. This incident cut it off. No more. Because of the trauma that she sustained. And I get it. There were doctors who gave their opinions. For example, the defense brought Dr. Rosenberg. Nice guy, gentleman. He complimented me. Maybe he's doing that because he's a psychiatrist and he knows what to say to twist everything. But the point is, he got $40,000 to come here and basically tell us that the plaintiff didn't suffer any emotional injury. That's not the facts. The facts are Emani Ellis was working as security guard. There was a change.
Misbehaving.
Okay? It's very, very traumatic to be assaulted and battered. I can only imagine the embarrassment, the emotions, the pain that Miss Emani Ellis suffered. Now, in this case, there was overwhelming testimony that Miss Ellis was working as a security guard at the time of the incident. There's no question. She was in full uniform. She had a badge on. Even the defendant admitted, yes, I understood that this person was a security guard. And there has to be some level of respect. These are not doormen or doorwomen.
Shock and
the
horror.
Defendant, when she came to the building, instead of listening to the plaintiff, to listening to her commands, you got to do this, you got to do that, please leave the building. Different commands were given to her, which none were followed. They were all ignored.
I mean, she doesn't have that much authority. And just, I don't know, like arrest somebody.
Instead, the defendant thought that, Miss Ellis was on her phone. She was telling people that I'm here. These were the thoughts that were going through her head at the time, and she's testified to those. However, that's not the case. Miss Ellis testified that she's never had a fight before. She's never done anything to harm anybody. She's never had any fight with anybody. And her mother and her grandmother also testified. She's a model citizen. Yeah. She's a hardworking person, and she simply,
I think everybody,
her whole goal of doing this, to be here and sit here and go through this, is so she
could a little too much.
Move on with her life. Sometimes people have to be heard. So by you all being here and hearing everything that's gone on, you have given her a sense of closure where she can move on and go on to the next step and the next phase. She's only 32 years old, and she has plans. She has plans to do other things in her life.
You can literally.
So we're very thankful that you gave us that opportunity. Each and every one of you, we're very thankful.
Most places. I think it's up to
the other thing I wanted to mention is
it's not an overall thing.
It would be impossible for someone to be videotaping someone and be on a phone call at the same time. I tried it myself. And the error message that you would get if you tried it is recording video is not available while on the call. So it couldn't be. The two of them couldn't be done at the same time. Miss Ellis told Cardi B multiple times, I am not recording you. I am not telling anybody that you are here. I'm simply doing my job. And instead of maybe agreeing or investigating further, Miss Almanzar, Cardi B got angry and started yelling and cursing and spitting on Miss Ellis and calling her different words, using the N word to disrespect her, calling her the B word, calling her fat, anything to try to trigger her and make her upset. And embarrass her. Sometimes words are more painful than the physical. And to add insult to injury, she then cut her face and caused a scar on her face. And what happened then? Miss Ellis had to go see different doctors. The court did read about Dr. Scher, a sentence that basically that there's this undisputed Dr. Scher died. And Miss Ellis basically testified that initially, a couple months after the incident, she saw Dr. McKenzie, a psychologist, through her workers' compensation. She was given that. She got 7 visits with that doctor. During that time, she also saw Dr. Scher, who was another plastic surgeon. Unfortunately, we don't have him here. We don't have his records because he passed away. So that's why that was read to you in open court, so that it's some
But they did
some
pull her
sense of
phone records,
fairness.
if I remember right.
Why there's no
Called her
records
phone
of Dr. Scher.
Objection, Your Honor.
But I don't think they actually did too much about it.
Then we learned throughout the case that when Cardi B came to the building,
years to work on it.
she caused a disturbance. She caused a disturbance. She was yelling and screaming at the top of her lungs, going crazy, yelling and screaming, to the point where 2 other witnesses, the Miss Malcolm, which was the secretary of the doctor, and Dr. David Finke, was so loud that those 2 people came out after about 40 to 50 seconds. Now, the issue with that is those 2 witnesses didn't see the 4 things that happened before that, which happened in the 40 to 50 seconds before. So yes, they're witnesses, but they're not witnesses to that first part, that first segment, which would include taking a swing at Miss Ellis, spitting on Miss Ellis, calling her the N-word, and ultimately cutting her face. None of that was seen by those 2 witnesses. So yeah, they're witnesses, but they're witnesses to the aftermath. They're witnesses to what happened afterwards. They're not eyewitnesses. They don't know what really happened. And when they arrived, Miss Ellis was so upset. Can you imagine all those 4 things happening, being disrespected, embarrassed? Who knows what else happened?
It's worth $20 million.
All of that was done to her, and she still was able to contain herself to a certain degree. But yeah, sure. I mean, naturally, she was angry. She was emotional. So when these 2 witnesses come out of their offices, they can only see an angry person. They didn't see what led up to that. And they had assumed that it's her fault, maybe, or that she did something wrong. But again, those 2 witnesses didn't really see much. They saw something after the fact. And then you have Miss Malcolm, who decided on her own, this was her choice, to squeeze herself in between the 2 people. Well, that's a risk that she took. And if she somehow got a cut to her face or a scratch or something, well, we don't know who did that. We really don't know. She didn't even know. Miss Malcolm testified that she did not know who scratched her face. She has no idea. What does that mean? It could be from either one. It could be from the commotion that's going on. These things happen so fast, we have no real idea as to what really happened. Unfortunately, there was no video camera there. There was no other witnesses that actually saw it. So it really comes down to one thing. Do you believe Miss Ellis?
No.
Why not? You should.
Really? She's
a hard-working security guard. She was doing her job with no prior anything.
What? Is that video me, Lady and Greg? Are you using me? So that's fine. I approve.
At some point during the trial, the defendant showed you Exhibit 232. You all remember this photograph? Exhibit 232. This is a photograph. Now, the issue with this photograph is there's really no way to know the date that this photograph was taken. There's no way to know. We don't know when it was taken.
Objection.
There is no proof of when this photograph was taken. It could have been taken at any time, before or after the incident. It could have been, and in this case, In this case, the defendant testified that this photograph was taken on the date of the incident.
Objection, Your Honor. Overruled.
That
I'm
was her
surprised
testimony.
the judge isn't yelling at her, to be quite honest.
But where's the proof? Do you really believe that a celebrity can't prove when this photograph was taken? She testified that this photograph was taken at the All-Star, NBA All-Star game. There's no proof of that anywhere. That's just false. There is proof of when this photograph was taken.
That would have been us if
It
we would have
just
listened to all
wasn't
that
given to
jury
us. It wasn't
instructions.
provided to us. So we can't rely on this photograph because there's no date on this photograph.
Where's Savage with his photograph song? Oh my goodness, I spelled arguments wrong again. It is one of those muscle memory words that get me every freaking
The
time.
next thing that Miss Ellis did is she made an incident report. 2 days after the incident, Miss Ellis wrote an email to her boss and followed what she was supposed to
Nobody's
do
perfect.
to explain all of the details of what happened to her. And she did follow company policy and did what they asked her to do. She called her supervisor, made an incident report, and did everything possible to document all of the different things that happened to her on that date of February 24th, 2018.
To be fair, typos are just no.
The other important issue is Cardi B testified that she came to the building, at least downstairs at the building. She had a security guard with her, Mr. Newton. Mr. Newton, that's her security guard. He didn't testify in this case. Why not?
Oh,
Where is he?
bro. You're just weird.
Disappeared?
I don't get called
Miss
celebrity
Ellis
names.
testified that when she saw this security guard downstairs in the lobby, she met with him there, Mr. Newton apologized
Objection, Your Honor.
for what happened.
Overruled.
Mr. Newton should have testified in this case and could have testified in this case, but he didn't.
Why didn't you call
And
him?
there is a jury instruction, KC Jury Instruction 203, which deals with a party having power to produce better evidence.
The burden's
The
on you,
jury
though,
instruction
sir.
states, you may consider the ability of each party to provide evidence. If a party provided weaker evidence when it could have provided stronger evidence, you may distrust the weaker evidence. That's what the law is. So where is Mr. Newton? I don't know. He was on the witness list. He should have came here and testified.
60.
Another important fact is if a witness is not credible on one point, you can disregard their entire testimony. When you go back into the jury room, you will have all of these different jury instructions. And each jury instruction will be there for you where you can read and understand what the law is and how it applies to this case.
All right, slow down on the grades, Summer.
And as I told you before, testimony is evidence, and you can rely on testimony alone to come up with your verdict. KC 107 states, do not make any decision simply because there were more witnesses on one side than on the other side. If you believe it to be true, the testimony of a single witness is enough to prove a fact. So in this case, you've heard from different witnesses. Just because one side may have more witnesses or less, that's not how it works. One witness is sufficient to prove a fact.
He called more witnesses. So, what a weird thing to say.
You initially heard that Miss Ellis saw the Dr. Nicole McKenzie. Dr. McKenzie testified. She's a psychologist. She treated the patient in her office, between her and other providers in her office, a total of 7 visits for a period of 8 months. Miss Ellis did seek psychological care and received it. She also, as I said, went to Dr. Scher. Dr. Scher advised her that he could not do the plastic surgery for a couple of reasons. One is you have to wait at least a year. You have to wait at least 1 year, 1 to 2 years to determine if the scar will become a keloid. I'm sorry, if the cut will become a keloid, if it will become a scar. Sometimes it may go away on its own. In this case, it did not go away. After that time period, if we all remember that in April of 2020, the pandemic occurred. We had this pandemic outbreak where everything was closed. You can't just go and have elective surgery. So the case was delayed. Medical treatment was delayed. That's why Miss Ellis waited.
Miss Caring.
Another factor is affordability. She had to find a doctor. We had to help her find a doctor that was willing to work on a lean basis. Dr. Mulliken testified that he would agree that he treated her on a lean basis. What that means is she still owes the money. However, in a court case, what happens is the doctor will agree to treat the patient and delay payment.
So she's what, like
delay getting paid. That's what Dr. Mulliken did.
$40,000 in debt for sure from this whole thing?
Dr. Mulliken testified that he fully examined Miss Ellis. He then decided, with his expertise as a board-certified plastic surgeon, that it would be beneficial for Miss Ellis to have plastic surgery and have this done in a surgery center. 2 different surgeries were done over a period of 3 to 4 months so that Miss Ellis could there were 2 issues. She had hypersensitivity, a little bit of hypersensitivity, and also as a woman, she doesn't want to have a scar to her face. And all the time, every day, waking up in the morning, looking in the mirror, remembering the event, it reminded her. It does remind.
Sir. Literally, get out of here.
Now, the defendant had the ability to hire their own plastic surgeon and have their own expert witness.
I'm sorry.
And in this case, the defendant decided not to hire one. So what does that mean? What that means is you really got to take what Dr. Mulliken says with a lot of importance, a lot of truth. There is no other doctor from the defense side. They could have spent
but he had
money
like
and hired
40,000 reasons to
here
say that, though.
and tell us, yeah, Dr. Mulliken's work is no good, or she could have done something different.
40,000
We don't have that here. You have one doctor on the plaintiff's side basically explaining all of his expert opinions. And he's a board-certified plastic surgeon for 30 years. He's affiliated with UCLA, and even testified that he, in his career currently, does teach medical students at UCLA to help them in their careers of becoming plastic surgeons themselves.
I'll be back.
Now, when you go back into the jury room, you'll see Dr. Mulliken's records and bills that are part of this case. They've been admitted into evidence, and you will see his medical report, and you will see his medical bills. Those are admitted into evidence. You'll have that in the jury room. so you can see it for yourselves. And if you remember, even Dr. Rosenberg had testified that he has seen Dr. Mulliken in other cases. He's been an expert in other cases working alongside Dr. Mulliken. And this is a very well-respected doctor. He went to Yale Medical School. Even Dr. Rosenberg testified that he had impressive credentials. He acknowledged that fact. And the other thing that I wanted to discuss would be the fingernails. The Cardi B testified that most of the time she would have long fingernails of 3 inches. That's her style. That's what she did. And in this case, not only did she have these long, sharp fingernails, she also had rhinestones. If you remember Dr. Finke, he was a fingernail, that was his thing. And he basically said he remembers the rhinestones, that they were protruding.
Objection, Your Honor.
They were raised.
Sustained.
When Cardi B testified, she acknowledged that she refused to listen to Miss Ellis, who was a security guard on duty at the time. There was also testimony by Cardi B that the two of them were chest to chest, touching. This was a touching that Miss Ellis didn't want. Miss Ellis didn't want to be connected to Cardi B physically, but Cardi B made that happen, and that's an unlawful touching. That alone, aside from the rest, that alone, Cardi B admitted to that fact. She said, that is what I did. I was chest to chest with Miss Ellis. Cardi B even testified that she was yelling and screaming so much that she acknowledged that it was possible that her spit went on to Miss Ellis. That was in the testimony. When Miss Ellis told Cardi B to leave the building, she should have left the building. Miss Ellis was hired by the owner of the building to keep the building secure and safe for tenants and other patients and visitors. Cardi B refused to listen to the security guard who was working there. At some point, Cardi B caused such a disturbance that what she was doing was a trespassing. You cannot be on the property when the owner or an extension of the owner tells you you have to leave. You have to leave. Miss Ellis's mother, Leanne Schmidt, testified. She testified that Miss Ellis obtained the scar to her left cheek as a result of this incident.
Objection, Your Honor. Sustained.
Miss Ellis's mother testified that she recalled seeing the scar after this incident. Miss Ellis's mother testified that she saw changes in her daughter after this incident. Same with Miss Ellis's grandmother, Diane Schmidt. She also testified that she recalled seeing the scar after this incident, and that she noticed a marked difference in Miss Ellis after the incident. That's her granddaughter. The defense put on a Dr. Rosenberg, who was a hired gun, received $40,000 for this case and makes millions of dollars in this type of work. He criticized the Kaiser Hospital for not writing down that Miss Ellis had emotional injuries when she. When Miss Ellis went to Kaiser Permanente for vaginal discharge in 2022, Dr. Rosenberg testified that there was an inconsistency when Miss Ellis went to Kaiser and didn't tell them about her emotional injuries. Why I'm bringing this up is very simple. When someone goes to an orthopedic surgeon, they don't talk about dental injuries. When someone goes to a gynecologist, they don't talk about emotional injuries. What really happens is when someone goes to a psychologist or psychiatrist, they tell them about their emotional injuries. When someone goes to a dentist, they tell them about their broken teeth. When someone goes to an orthopedic surgeon,
Not true, sir.
they tell them about their neck pain, their back pain, their left foot pain, left ankle pain. This idea that every time you go to a doctor, no matter what specialty, you have to cover all these things is not real. It's not real life. Some of the doctors
Yes,
will
it
say,
is.
don't tell me, I don't want to know. I'm not writing it down.
Not at all how going to a doctor works, sir. Has he been?
We've all gone to doctors,
doctor?
and we all know when we go to a
Or
specialist.
does his mommy fill
we'll
out his
focus
paperwork
on
still
why
or
we're there.
something?
Miss Ellis went to Kaiser Permanente Hospital for vaginal discharge in 2022 and different things throughout her time there. She didn't go there for emotional injuries. She didn't go to the psychiatric care there. She didn't get any psychological care there. None of that. So for Dr. Rosenberg to sit there and tell us there's inconsistencies because in Kaiser, she didn't tell him about the emotional injuries, it just doesn't make sense.
False there. Does anybody else have to tell, no matter what doctor they're going to, their medical history?
I want to talk a little bit more about Miss Malcolm.
I do here in
I just want
Ohio.
to remind you
I
that
don't know.
when
about
Miss
his
Malcolm
Spanish
came out, 40 to 50 seconds had already transpired. She came to the aftermath. I know I've already said that, but I really want to hammer this home that she is not a witness to what happened before. It's like a car accident. There's two cars, they have an accident. If a third car comes down the road a minute later and hits them, it's completely different. It has nothing to do with it. So that was inserted into this case to, in a sense, to muddy the waters, to kind of cloud what really happened.
I mean,
What really happened here in this case is Miss Ellis was working as a security guard. She had to be there. She was working there as a security guard. And Cardi B came along and thought she's above the law. She could do and say whatever she wants and attack Miss Ellis emotionally, physically, and do whatever she wants in a building which is inappropriate. We all know that when we go to a building, we got to be respectful, especially to security guards that are working there. These are not just doormen or doorwomen opening the door for you. You have to follow along with what they say. Next, we heard from Dr. Finke. Want to talk about inconsistencies? There was an inconsistency
it's fine.
between
I'm
Malcolm
fine. Something just fell
and
off.
Finke.
It scared me.
Malcolm said, I don't know how I got this scratch on my forehead. I don't know. Dr. Finke comes out and says that Malcolm told him that Ellis had scratched her face. That's not true. That was never said. So this, if you remember, this is a 7.5-year-old incident.
Right.
And that's a few thousand days ago. It takes a lot of time has passed, and an incident can be perceived differently by different people. So Miss Malcolm could have perceived it one way, and Dr. Finke could have perceived it one way. But
Your
again,
client
same
could have
problem with him
perceived
is
it a different way, which sounds
when
like
he
what
came,
happened.
everything already been done. The whole incident already happened. The injury was already complete. And really, this comes down to believing Miss Ellis. You give me no reason not to. She's been truthful through me and through herself and through her witnesses to give you whatever is there, to provide for you all that she could with the things that she has available to her, so that you could give her the peace of mind, the closure. And yes, she is asking to be compensated for the loss that she sustained. She lost something, and by you compensating her with money damages, you're then evening the playing field. You're giving her what she lost back. So she's not trying to gain something that she's not entitled to. Unfortunately, she was abused, she was harmed, she was assaulted and battered by Cardi B, and Cardi B needs to pay for that.
Right,
It needs to be
charges.
accountable. We need to hold her accountable. We should not just let her walk away and say, oh, everything you did was okay, and yeah, do it again. Now, in addition to seeing the two plastic surgeons and Dr. McKinsey, Miss Ellis also received another 12 visits of, she testified that she saw a psychologist, Dr. Avila, and other
Objection, Your Honor.
people in
Assisting
his office.
Violation of the court's order.
Move on, confirmation.
This guy. Oh my gosh. There's so many objections all the time. I think so too.
The other thing that Cardi B failed to do or could have done is she could have filed a cross complaint.
Objection, Your Honor.
Maybe she's not pretty like her clients. You know?
All right. And then I want to go over a little bit about the medical bills. So you don't have to get it exact. It doesn't have to be an exact number. But there was testimony in this case that Miss Ellis had $17,500 in medical bills from Dr. Mulliken, the plastic surgeon, and another $18,000 in psychological care through her work comp and other things.
Objection, Your Honor.
There was also testimony from Dr. Mulliken that he believed Miss Ellis could benefit from one more surgical procedure, another one, to make it better. The cost of that was $15,000.
Objection, Your Honor.
Over. The $15,000 that would be paid for that would, in Dr. Mulliken's expert opinion, it would make the scar better, meaning it would reduce, it would, basically what I'm saying is there's still some scar on her face. And if you want to look at it, you're more than welcome. You can have her walk around, you can look at it for yourself. There is still some scar on her face. It's still there. It still bothers her. So that's why I'm asking that not only you give her the $17,500 in her past medical bills for the scar, that you give her another $15,000 for the future scar revision treatment. She didn't deserve this. She didn't deserve to be scratched and cut and spit on and all these things.
Yes.
All of the things that happened to Miss Ellis,
I'll send you some concealer, babe.
they're wrong. And we want to make this wrong right. And how can we do that? Through each one of you. You have the power to make this wrong right and close the books for Miss Ellis so she can move on with her life as much as she possibly could. And yes, the only way to do that right now for today's purposes is to reimburse her for the losses that she sustained. Those are the medical bills, the past,
always,
and the future. The other thing that is an important way of compensating Miss Ellis is for her pain and suffering. In every case where there's medical bills and there's medical damages, a component of that is pain and suffering. There is really no way, there's no exact math to that. So for instance, if you said,
$24 million,
I want to give her the $17,500, I want to give her the $15,000, and I want to give her another $250,000 for pain and suffering. You are allowed to do that. It is a number that you can come up with. During the 7.5 years that she's been suffering, you may say, I would like to give her $100 a day. For 1 year, that's $36,000. And for 7 years, that comes up to $270,000. We're not looking for millions of dollars like the defendant said. That's not what we're looking for.
Isn't your claim
We're
$24
really
million?
looking a simple amount of money that can make her whole, give her something that's fair so she can get some form of compensation, some form of closure, and move on with her life. That is all we're asking you to do.
Yeah. That is crazy. Zero. Good morning, Savage. I was calling for you earlier because there was
when you
mention of a
go
photograph.
into the
So
jury room,
I was like, where are you?
you'll be given a verdict form. And the verdict form will basically state, it covers all of the different areas of this case. The first section A is the assault and battery. They are, in a sense, separate because the assault is the swing and the battery is the scratch and the cut to her face. However, it's very clear. Did plaintiff Emani Ellis prove all of the following elements of battery? And then it goes down, it breaks it down. Defendant Belcalis Marlenis Almanzar touched Miss Ellis with the intent to harm or offend Miss Ellis. Miss Ellis did not consent to being touched. Miss Ellis was harmed or
Daryl might have
offended
done a
by
better
Miss
job.
Almanzar's conduct. A reasonable person in Miss Ellis's situation would have been offended by the touching. I would say that yes, all four of those have been done here. So when you get to that question, there is going to be on the right side. It's not broken down into 4 parts. It's all as a whole. So if you want to give money damages to Miss Ellis, you would check yes. Okay, and then you go to the next question. Did Miss Ellis prove all of the following elements of assault? And again, it breaks down for you the 5 different parts. Miss Ellis acted with the intent to cause harmful or offensive contact with Miss Ellis. Miss Ellis reasonably believed that she was about to be touched in a harmful or an offensive manner. Miss Ellis did not consent to Miss Almanzar's conduct.
That she
Miss
does.
Ellis was harmed, and Miss Almanzar's conduct was a substantial factor
Totally.
in causing Miss Ellis's harm. Again,
$800.
if you want to give her money damages, you would check yes. That would be page 2, both of those. Then you have question number 3. Did Miss Almanzar prove all of the following elements of self-defense? So the defense is trying to argue that all the things that Miss Almanzar did were in self-defense. There is no testimony of self-defense here. In fact, Miss Almanzar herself, her position was, I didn't touch anybody and nobody touched me. So self-defense, no. You would say no. Then you can go, then question number 4 speaks about the damages that she suffered. Past medical expenses. That's where you would put in an amount of money through the testimony that you heard and through all of the exhibits. You would put an amount of money that you believe Miss Ellis incurred in this incident. So you will have in the jury room exhibit number 4. You'll have exhibit number 4. It's been marked at the bottom right corner. You'll have exhibit 4-1 through exhibit 4-6. And then it will skip over and you will go to the bills, which will be 4-13, 4-14, and 4-15. If you combine all of these bills, you will get $16,500.
That's
So past
funny.
medical expenses would be $16,500. That would be what you
I'm
would
over
write
him.
there if you want to give her the cost of all the plastic surgery she had to go through up until now.
I mean, I still wouldn't give her
The
that
future
either.
economic loss is the future.
She had a better
plastic
chance, I
surgery.
think.
Dr. Mulliken stated that Miss Ellis would benefit from a future plastic surgery of $15,000. So you'd write $15,000 in that box. Pain and suffering. Again, there is past pain and suffering and future pain and suffering. The court read a time frame for you of how many more years Miss Ellis will live. And the jury instruction life expectancy, 3932, basically states that Miss Ellis will live for another 50 years. This is an estimate. It's not 100% certain, but it's the best estimate that we have based on all kind of statistics. She has 50 more years to live. So if you feel that she's going to suffer from this point forward, then you can award her money damages for the future.
I thought she was healed.
And if you feel that she sustained pain and suffering in the past, then you can award her money for the 7.5 year time period.
That's crazy pain.
And again, you'll all have the jury instructions in the back when you go into the jury room. And the jury instruction on pain and suffering covers a whole bunch of different things. Very important. Very important.
Oh yes, you can join my no social media team. It's lovely on this
So
side.
I would take a look at that one.
I haven't had it in
Because
years.
it covers all of the different
It's
things.
Nice.
Embarrassment, pain and suffering, disfigurement, all of those.
I promise you'll survive.
If you look at 3905, it talks about physical pain, mental suffering, and or emotional distress. And it basically says that there's no fixed standard for deciding the amount of these damages. This is a number that you will come up with. It won't be based on chance or a flip of a coin, but it will be a number that you come up with. If you decide you want to give her $500,000, you can do that. If you want to give her more, you can do that. So for past non-economic loss, you should put a number there. Because if you don't, the award will be thrown out. You got to have at least $1 there.
Mm,
You got to award some kind of pain and suffering.
you
It's
don't.
required.
No.
Now, the amount would be up to you. A lot of times, some people say, well, 3 times medical bills, 10 times medical bills. This is an assault and battery. It's just not a simple car accident where it's just, some bumps and bruises. This is a serious, serious injury. Very serious.
Sir, I
And
can't
Miss
take
Ellis
that
has been suffering
seriously.
For the last 7.5 years.
Shut up.
What kind of
Is this
weight
worse than a
do we
car
put to
accident?
that? What kind of number do we attach to that? I don't know what number you're going to attach to that. But for purposes of now, for
I
example,
can't with him.
you could write $250,000 for the past pain and suffering. This was a violent attack. She was violated. She has a scar to her face now. She's gone through all kinds of medical treatment that she didn't have to go to. So much life was lost from her time-wise. You can't get it back. All this time that she's lost and feeling embarrassed and
Will.
all of that. What is the value of life? It's significant. We all went through the pandemic.
Jesus, you're bringing the pandemic
We all
now?
went through the pandemic, and we realized that after the pandemic, the value of life is much greater because we realized what life is really about.
Sure.
Future non-economic loss. Again, that's going to be for the 50 years going forward. You could pick what number you feel. Maybe you feel she's recovered. Maybe you feel she deserves another 10 years. Maybe the whole 50 years. I don't know what it is. But you as individual judges will work together as a team to come up with a number for the future non-economic loss. Then it goes into intentional infliction of emotional distress. Did Miss Ellis prove all the following elements of intentional infliction of emotional distress? Number one, Miss Almanzar engaged in extreme and outrageous conduct beyond mere insults, threats, indignities, annoyances, hurt feelings, or other trivialities that a reasonable person is expected to endure.
How about you?
Miss Almanzar intended to cause Miss Ellis emotional distress. Miss Ellis suffered severe emotional distress, and Miss Almanzar's extreme and outrageous conduct was a substantial factor in causing Miss Ellis to suffer severe emotional distress. If you believe that Miss Ellis sustains emotional distress, then you would, on number 5, you would say yes. Then
I actually
number
don't know
6,
what that means.
again,
What
it
does
says,
that mean?
did Miss Almanzar prove all of the following elements
ringing a
of the
bell.
privileged conduct defense? So again, it's similar to a self-defense of this, and it goes through a whole laundry list of different ways and finding excuses why the conduct was okay. So you would put no there if you believe that the conduct caused intentional infliction of emotional distress. Then number 7 has its own damages component. However, we've agreed and conceded to the fact that we don't want you to award damages for the same thing twice. It's not what our goal is. The goal is, if you feel there should be separate damages aside from the assault and battery for the emotional distress, then this is where you can give that amount of money. It'll be a separate and apart damage area for you to award more damages. Same
How many
breakdown.
jurors do you think are like
You can
rolling
give
their eyes
past
right
medical
now?
Expenses, obviously, past and
We're just
future medical
staring at
expenses.
him like,
In this, if you awarded in the first box, then you would say, 0 and 0, because we're not asked double dipping here. That's not our goal. However, pain and suffering. If you want to give separate pain and suffering for the emotional distress, separate pain and suffering for the emotional distress from the past and the future, this is where you could do it. You could say, okay, well, we're going to give 50,000 additional for the past, 50,000 additional for the future, and then we're going to move on to the last part,
okay.
which is negligence and contributory negligence. And again, this is all from the form that you're all going to see when you go into the jury room. And I'll close with this. Did Miss Ellis prove all of the following elements of negligence? Miss Almanzar was negligent. Miss Almanzar's negligence caused Miss Ellis to suffer physical harm rather than only emotional distress, and Miss Almanzar's negligence was a substantial factor in causing Miss Ellis's harm. So what that means is, for example, was Miss Almanzar, was Cardi B negligent in thinking that the plaintiff was disseminating her privacy to others, photographing her, videotaping her? If you believe that Miss Almanzar, Cardi B, was mistaken, then that would be negligence. She was negligent. She negligently thought that all these things were happening. And then again, it asks for the damages. Same thing. 0 and 0 for the past and future medical expenses if you have given it in the first phase. So there's different areas. Maybe you'll say, well, I don't really believe there was this, but I believe there was that. So anywhere on the form, we would ask that you award Miss Ellis her medical bills of $16,500 for the past and $15,000 for the future, and in different boxes and different areas of this form to award her the pain and suffering that you feel is fair.
Can I get a
all
jumbo
the things
crown?
she went through, the assault, the battery, the emotional distress, all that she should be compensated for. And then there's a box, did Miss Almanzar prove all of the following elements of contributory negligence? Miss Ellis was negligent. Miss Ellis' negligence was a substantial factor in causing her own harm. Well, Cardi B testified that Miss Ellis didn't touch her, didn't do anything. There was no physical contact. That was the testimony of Cardi B. So how can she say that there was contributory negligence? What did the security do wrong? So the answer would be no. And then it goes to number 11. What percentage of responsibility for Miss Ellis's harm do you assign to Miss Almanzar? Say 100%.
Part of the job. It's not
Miss
great.
Ellis, 0.
You know, you hope they don't get harmed, but
And the
also
final
like
page deals with
she said she wanted to be a
punitive
cop.
damages.
Thank freaking God.
Did you answer
She's not.
question 4 or 7? And you look back and
Yes,
if you did, which is the damages, then you put yes.
Or Callie.
And then it says, did Miss Ellis prove by clear and convincing proof that Miss Almanzar engaged in conduct with malice, oppression, or fraud? And then you would look at the case as a whole and kind of come up with your opinion. Did all of these things combined, did all of this thing that Miss Ellis went through? And remember, it's or, so it's either malice, oppression, or fraud. So if you agree that there was, then you would say yes here.
Fraud and oppression. How did we get here?
So at this point, I'm going to turn it over to my counterpart.
Sounds like a made-up
They
place.
will
TJ.
obviously contradict everything I will say. I've told you. And then I will have a chance to come back and rebuttal and just clean up anything that was said. At this point, I'm basically Miss Ellis's mouthpiece, and work with her as best I could to convey all of the things that she wants you to know. I worked with her personally to tell you all what she went through, and I did the best that I could with what I have. And we really, no matter what happens, whatever is supposed to happen will happen, because that's what's supposed to happen. And I want to thank you each individually for being here. Each of you as individual judges, we're thanking you very much. Thank you so much for hearing the story as to what Miss Emani Ellis went through. And I'm asking you to award Miss Ellis an amount of money that you think is fair that will make her whole for the losses that she suffered in this case. Thank you very much.
All right. Thank you, counsel.
He's been a lawyer for 20 years, you guys.
Okay. All right. Defense ready to proceed?
We are, but I would think a break would be appropriate.
Does anyone want a break? We got started late. Okay. Why don't we take a short break? Why don't we resume back at 11:25? In the meantime, please not discuss the case with anyone, including other jurors.
We don't have to
Don't form
do
any
that.
teams or
All
do
right.
any research. We'll see
That
you
was
at-
something. Let's
Cardi
get into the defense. That was he just threw everything at it. Just threw everything. I mean, we ended up on whatever's going to happen is destiny. It's fine. It's fine. You guys are crazy. I don't understand how some people have the jobs and careers they do. Because, hold on. I don't know where this picks up. Oh, probably here. No, wait. They're arguing something. Oh, those awful lights. Okay. 0 is fair. -0 is better. Oh my goodness. Something else, that guy. All right.
For the members of our jury and our alternate. And before we get started with the defense closing argument, you heard a number of objections during plaintiff's closing. Some were procedural or evidentiary in nature, but some of them were based on facts that weren't introduced during the trial. And so that's why I was sustaining those objections. To the extent that plaintiff's counsel mentioned any facts that weren't presented in evidence during the trial, please disregard any and all of those facts that he represented that weren't actually accepted into evidence during the trial. Okay? All right. With that, defense can give their closing.
Thank you.
Good morning, everyone. I'd like to start by thanking all of you for taking the time to participate as jurors. This is how our system works, and it wouldn't work without jurors. And I'd like to thank you on behalf of both Cardi, my colleagues, and myself. I'd like to just mention quickly that counsel argued that Cardi swore and used profanities in the courtroom and that was disrespectful. Actually, all she was doing was repeating under oath what was said. In fact, Ms. Ellis, plaintiff, used profanities to describe what she heard. Counsel used profanities, and I have to admit I used profanities, but just to tell you what was supposedly said. Cardi has never gratuitously sworn at any point in this courtroom, and the suggestion that you should be prejudiced against her because of that is just unfounded and offensive. Last Monday, it seems like it's a lot longer ago, but last Monday in the opening statement, I told you what I expected the evidence would be, and I told you that you can treat my statements and counsel's statements as promises of what they were going to show. And then I would ask you at some point today to decide who kept their promises and who didn't. I also told you that I would have a second chance to talk to you directly after all the evidence is in. The evidence is in, witnesses have testified, that exhibits have been admitted. And if you remember, the judge told you the first day that the way trials work is that bits and pieces of evidence come in. This is my opportunity to tell you how we think those bits and pieces come together and how they establish that Cardi, you should decide in Cardi's favor. First, there's a couple of things I ask that you keep in mind throughout the rest of the trial. If you remember, Judge Fusselman told you last Monday morning that the reason we have juries is because they have diverse backgrounds and they have common sense. He reiterated how important common sense was when he said, we just need you to exercise common sense and evaluate, is this witness being consistent? Is this witness saying things, something that doesn't seem true? And does this piece of evidence fit in with all the other pieces that have been presented in this case? I respectfully suggest to you that using your common sense, there's only one possible outcome in this case, and that is a decision in favor of Cardi. Now, you'll be instructed that plaintiff bears the burden of proof of establishing her claim. She must convince you that the evidence shows that by 50% or more, her claims are valid. Now, there's another way of putting it is, and you'll see this in the jury instructions that you get from the judge, if plaintiff fails to prove that her version of what happened is more likely than not what did in fact happen, you must decide the case in Cardi's favor. The concept of a preponderance of the evidence can be demonstrated by this slide. That's 50-50. That's where the plaintiff has put on as much evidence of as the defendant of a fact, and you'll see that that's where people talk about the 51%. But it is crucial to keep in mind that plaintiff doesn't start at 50%, she starts at 0. She has to raise that needle from 0 to 50% and more. She has to go beyond 50%, or you have to find for Cardi. Third, there is no dispute that there was yelling and some curse words in the hallway at the medical building around 1:30 p.m. on February 24th, 2018. But the judge will provide you with the jury instructions. In fact, he already has, that arguing, yelling, even using profanity is not something you can sue over. That's just part of normal life, and that is what we're supposed to bear.
Put on your big kid pants.
In fact, that would be crazy that someone could sue if they cause someone else to use profanity.
The question really is whether Cardi ever struck plaintiff, and who caused this confrontation? Who caused the incident? And the answer is that the evidence in this case overwhelmingly proves that Cardi did not strike plaintiff, and Cardi did not cause this encounter. As a result, plaintiff has failed to establish by the evidence we heard last week that by a preponderance of the evidence, more likely than not, that Cardi was the cause. The way I'm going to try and do this in a very organized fashion, and the way I'm going to do it is going to be demonstrated by this chart. And so we have on the left-hand side plaintiff's evidence, then on the right-hand side defendant's evidence. Now, plaintiff started with her own testimony. Last Monday, she testified under oath. Importantly, though, in plaintiff's evidence, she never called as a witness either Tiara Malcolm or Dr. Finke, both of whom were present.
Objection, Your Honor.
Both of whom
Overruled.
were present
Don't care. Overruled.
at this very time of the incident. Now, plaintiff's evidence, plaintiff's testimony, and we should keep in mind that just because plaintiff says something doesn't make it true. Okay? She has her version, but the fact that she alone says it does not actually make it true. And this later this morning, maybe stretch into afternoon, I'll tell you or I'll identify the many inconsistencies in plaintiff's story over the course of this litigation, actually going back to February 26, 2018, when she did her incident report. In the meantime, plaintiff claims that she was assaulted and scratched or cut on February 24, 2018. But plaintiff did not see a doctor. She didn't go to an emergency room. She didn't call the police or make a police report.
Objection, Your Honor.
And she actually testified she did not know if the scratch that has supposedly ruined her life was even bleeding. She also testified last week that she didn't even put a Band-Aid on the scratch. What did she do? She claims that Cardi mauled her, basically, cut her face, and this woman went home, and what did she do? She took a nap. That was her own testimony. She took a nap. The fact that on February 24, 2018, plaintiff just went home and took a nap is corroborated by plaintiff's own T-Bell cell phone records for that day. As you'll see, and this was an admitted exhibit, you'll be able to see it, it's exhibit 200. She gets calls and she makes calls from 11:20 a.m. all the way to 3:35 p.m. and then nothing until 9:08. That's when she took her nap. That's what she did. She didn't call a doctor. She didn't go to the hospital. She didn't put a Band-Aid on her face. She took a nap. Now, importantly, when plaintiff testified as her own first witness in her case, she admitted that in 2021, she hit her head in a car accident. She's put on no proof that that wasn't the source of the scar, which is a pretty obvious reason that she would have a scar if she had one. And importantly, 2021, a car accident in 2021 is after plaintiff told Dr. McKenna in April 2018 that Cardi almost touched her with a fingernail, not touched her with a fingernail, and I'll talk more about that later, but almost touched her. So after the plaintiff tells Dr. McKenna, her workers' comp physician or psychologist, that Cardi almost touched her, plaintiff was then in a car accident, hit her head, and that's when she went to Dr. Mulliken. She went to plastic surgery 4 years later after being in a car accident.
Objection on this case.
Plaintiff also testified, by the way, that she was in another accident in 2023 and filed another lawsuit over that one. Plaintiff has argued, and he said again today that plaintiff's counsel has argued and said again today that plaintiff has some special status as a security guard. But she testified she became a security guard by having her fingerprints taken and sent to California. That's it. That doesn't make her a policeman. Also importantly, when testifying last Monday, plaintiff admitted that she knew on February 24, 2018, that Cardi was in the medical building because Cardi was going to a medical appointment. Plaintiff's own testimony establishes that at 1:30 p.m. on that Saturday, plaintiff could have been at that security guard booth that counsel showed you a photograph of. She could have been on her rounds, going through the whole building. She could have been in parking, checking, because that's what security guards do. But plaintiff, who has testified she was a fan, just happened to be outside Dr. Finke's office when Cardi B was showing up to see an obstetrician. From those facts alone, you can infer that she was actually laying in wait. She wanted to photograph and videotape Cardi. She would then be able to post it on YouTube, maybe start a new career, be a follower, I don't know. But from the facts you've seen in this and heard in this case, she very well could have done that on purpose. But even if we assume that plaintiff just happened to run into Cardi B in a 5-story building that afternoon, plaintiff testified that she knew Cardi thought that plaintiff was using plaintiff's phone to tell someone that Cardi was there and to videotape her. What would a reasonable person do at that point? By her own testimony, plaintiff had the chance to be professional and avoid all of this by putting her phone away. That's all she had to do. But the evidence is she kept that phone in her hand all the way through as she advanced on Cardi B and forced her into a corner in the hallway where Tiara Malcolm found her. Plaintiff also testified that after she was fired as a security guard, she got a new job that paid more money. That's why you don't hear any claim for lost wages or anything like that. She was better off.
Unfortunately, you're not claiming lost wages.
Oh,
That summarizes what plaintiff testified to, and I'll talk later about the inconsistencies in it. But let's talk about her second and third witnesses, plaintiff's mother and grandmother. Both very charming. But her mother and her grandmother weren't in the hallway that afternoon. Her mother and her grandmother were not witnesses. And they testified that because plaintiff is the mother's daughter or the grandmother's grandchild, that they believe her. They don't need evidence. They just hear what she says. And that's understandable, of course. We all have relatives and we hope our parents believe us and our grandparents. But remember what Judge Fusselman said at the very beginning, common sense. Okay. We all know that parents are not with their children every minute of the day. We all know that children don't always tell their parents everything. And they especially do not tell their parents that they're embarrassed or guilty about what got them fired. That's what plaintiff left out when she talked to her mother and her grandmother. Is anyone surprised that plaintiff did not tell her mother and grandmother that plaintiff cursed and yelled at a pregnant Cardi half her size, that plaintiff cornered Cardi in a medical building hallway, and that plaintiff knew she was probably going to get fired? Is that the kind of thing you'd say? Guess what, Mom? Guess what I did today? So it's completely understandable, using common sense, that the mother and grandmother would not know actually what happened. In fact, plaintiff didn't tell them that she had apologized in her incident report to Allied and the building for her own behavior. She left that out because I asked both the mother and the grandmother, did your daughter or granddaughter, tell you that? And they said no. So we know that plaintiff left that part out.
Convenient.
Plaintiff's mother and grandmother both said that plaintiff is a peacemaker. Okay. Well, that sure doesn't square with the testimony of Tiara Malcolm, Dr. Finke, or Cardi, and I'll discuss that later. And maybe what we take from that is she's a peacemaker when she gets her own way. We know what she's like. We've heard testimony what she's like when she doesn't get her own way. But there's another word for that other than peacemaker. It's a bully. Plaintiff's mother and grandmother both said they saw a scar on plaintiff's cheek. But on February 26, 2018, 2 days after the incident, plaintiff emailed her incident report
Cardi.
to her supervisor, Jasmine, stating that Cardi scratched plaintiff's nose. So how is it that the mother and grandmother are saying that, well, when this happened or around that time, our daughter said that Cardi had scratched her cheek. But in plaintiff's own incident report, she said she told her supervisor Cardi scratched her nose. A nose is not a cheek is not a nose, and there is something wrong about what's going on because, again, apply common sense. Plaintiff's mother testified that she saw a scar, but she didn't testify when she saw it. Counsel asked her, did you notice after the incident that Emani Ellis had a scar to her face? Answer, I did. When did she notice that? 2018, 2019, 2020? We don't know. And in response to one of your questions, because the judge was kind enough to allow jurors to ask questions, which doesn't happen all the time. You were lucky in that regard. One of your questions, the judge read, and in response, plaintiff's grandmother said she spoke with plaintiff right after the incident. Right after the incident, she spoke with plaintiff. But plaintiff testified last Monday. Question, you didn't call your grandmother though, did you? Answer, no. Okay. So again, common sense tells you something is very wrong here. Now, plaintiff's mother and grandmother testified that plaintiff became depressed. If so, there could have been many different reasons for it. And
I ate too many grapes.
For example, it could have been because she got fired. And as we'll see in a few minutes, she felt guilty. That's what plaintiff told Dr. McKenna in April. On April 26, 2018, the plaintiff told Dr. McKenna that she feels guilty. Ultimately, the testimony of plaintiff's mother and grandmother just doesn't move the needle for plaintiff. They weren't there, and they're relying on what plaintiff told them. Now, plaintiff's third group of witnesses is Dr. Mulliken. And that's what she offered to support her claim. Of course, Dr. Mulliken also wasn't there on February 24, 2018. He didn't witness what happened. Dr. Mulliken testified that plaintiff came to him in November 2022, or more than 4 years.
Googled what that meant. I love learning new things.
The alleged incident.
A liar in Spanish.
Dr. Mulliken is a plastic surgeon, not a psychiatrist.
You know, liar.
So counsel pointed out that Dr. Mulliken testified that plaintiff told him she has post-traumatic stress, anxiety, depression, and headache. But Dr. Mulliken said, that's what she told me. I did not make a diagnosis to that effect. That's just what she told me. Now, Dr. Mulliken, and I hope he's not insulted, but his testimony was confusing and inconsistent. He testified that in November of 2022, plaintiff had a scar, had 2 to 3 scars, had 3 scars, and even plaintiff doesn't claim that she has more than 1 scar. But Dr. Mulliken thought there were as many as possibly 3. Somehow the no scar from the beginning turned into 2 scars and then 3 scars. Also, though, Dr. Mulliken's own photograph, Exhibit 228, which he testified was taken with a digital camera before any treatment, sure doesn't appear to show the scar.
I mean, that's a fair assumption.
You'll have a copy of the actual photo. It's admitted as exhibit. You can look at it and you can decide. Counsel actually challenged you. Look at the photograph, and we invite you to. If you see a scar, that's news to us. And this is before she was treated.
Shine.
Importantly, Dr. Mulliken testified at his deposition. You've all heard about depositions. They're under oath. It's just like a trial, except there's no judge. And that the claim scar was about an inch long and most likely made by a right-handed person who scraped or clawed downward with 3 fingers. Okay, that's what he testified to. That's what was in his deposition, and that's what he testified to here. But plaintiff herself claimed in her deposition that Cardi jabbed her with a straightened index finger, like this. That's not a scrape. Your Honor, I don't think I need to ask for permission, but we'd like to show the, okay, then we'll show, this was played for the
Well played, sir.
jury
Well
before.
played.
It's Cardi's plaintiff's testimony as to how she was supposedly cut by Cardi.
When you say like this, she put her finger.
Pointing, yes, so like this, pointing her finger in my face, yes.
That is directly and irreconcilably in conflict with Dr. Mulligan's testimony that it was a right-handed person who scraped with an index finger and two other fingers downward. Those are completely different things. They don't correlate. The testimony is clear that plaintiff and her plastic surgeon have completely different explanations for the same claimed scar. And once again, common sense. Something's wrong here. Something is very, very wrong. Now, maybe the scar that Dr. Mulligan says he saw and his explanation, maybe it was a car accident. I don't know. But it is irreconcilable with plaintiff's own testimony that she was jabbed with the straightened finger. And to add to that, Cardi is not right-handed. I want to say that again. It's very important. Dr. Mulligan says that in his professional opinion, and counsel talked about how well-respected he is, that it was a right-handed person who scrapes three fingers downward across plaintiff's face. But Cardi is left-handed. She is not a right-handed person and could not have done that.
I don't
Plaintiff's
think that
counsel
argument
tried to get Dr.
works out,
Mulligan
though.
to testify that a left-handed person
Your right hand's
might
not
have made the
broken.
claims scar. But that's not his opinion. He admitted that it would be hard, in fact testified it would be hard for a left-handed person to reach across and strike a person on the opposite them on the left side of the face. Now, here's another important thing. Dr. Mulligan testified that he can't say when plaintiff got the claimed scar. He testified there's no way of knowing the age of the scar. That's important because plaintiff admits that she hit her head in a car accident in 2021, almost 2 years before the November 2022 appointment with Dr. Mulligan. And Dr. Mulligan also testified that he can't say whether the claimed scar was caused by an intervening accident or some other cause.
Objection on this case.
Ladies and gentlemen, you heard the evidence. Please rely on your recollection of the evidence and rely on your own recollection to the extent that it differs from counsel's representation.
And Your Honor, we also have a cite to the reporter's transcript. There are other odd things about Dr. Mulligan's testimony. For example, he calls a 3-minute long session of outpatient microneedling a small part of plaintiff's cheek, which serves, well, as reconstructive surgery and plastic surgery. A 3-minute microneedling session in his mind is reconstructive surgery and plastic surgery. Now let's talk about why he would say that. He has a broad version of surgery that enables him to charge an additional $11,000 for an operating room. He testified surgery is anything that includes a doctor, a nurse, a scrub technician, and an operating room. No matter what you're doing, even if it's microneedling, if it's pulling a splinter out, you go into that room and he charges $11,000. Dr. Mulligan testified he is the sole owner of the surgery center with that operating room. So he has a strong financial incentive to use and charge for that operating room, whether he's doing real reconstructive surgery or microneedling. Now, perhaps because his photograph doesn't seem to show the claimed 1-inch scar, Dr. Mulligan also provided confusing testimony about hidden scars under the skin. I don't know if you remember that. It had my head spinning. But he never testified. There's no testimony from Cardi, from Dr. Mulligan, or anyone else that plaintiff has a hidden scar. In fact, it's supposed to be this, really big embarrassment that she has this, terrible scar on her face that, you can decide whether you've seen it. You've walked by her. If you see a scar, well, No one else, a lot of us don't, I should say. Dr. Mulligan also testified that he charged $17,500 on a lien basis, which means he gets paid only if plaintiff wins or if plaintiff pays him. But plaintiff testified under counsel's own examination on Monday that she couldn't afford a $15,000 or $20,000 plastic surgery bill. So we know she's not going to pay Dr. Mulligan. Dr. Mulligan knows that he is going to get paid, if at all, his $17,500, only if his testimony helps plaintiff recover money in this case. That is a big incentive. And because of that risk, he testified he added a 20% premium to his bill. That's plaintiff's side of the scale, which keeps disappearing. And it pales in comparison to Cardi's side.
I do think Naranja is like the funnest
course,
way to say orange.
Cardi's evidence starts with Cardi's testimony.
Naranja.
Which will appear shortly. Thank you. Cardi is one of the 3 eyewitnesses who directly contradict plaintiff's story about what happened that day.
I couldn't help myself. I don't know much Spanish.
That in February 2018, she was pregnant. You may remember in this trial that plaintiff's counsel asked Cardi, why does that matter? You're pregnant. No one knows, but why does that matter? Well, it does. Right. It did matter, and Cardi testified, and you should consider, and I hope you remember Cardi's response. She felt her privacy was completely being violated, and that her medical issues are not anyone's business. Quote, especially something that is so sacred as your pregnancy. It's yours. No one knew she was pregnant. Her parents didn't know. And she shows up for an appointment, and this woman is photographing, filming her, and then getting belligerent. Now, I mentioned that Cardi testified her parents didn't know she was pregnant at the time, and it's common sense that no daughter would want their parent to find out that she's pregnant by social media. This was a secret. There were special arrangements made so that she could see an obstetrician while in LA on a Saturday. Now, Cardi testified that she came to Los Angeles for the NBA All-Stars weekend, and concerned, she made an appointment with the obstetrician for Saturday afternoon. I'll get to the photograph in a minute. Cardi testified that she got off the elevator to go to the doctor's office at about 1:30 on the 5th floor of that building, and plaintiff started filming and photographing her. Cardi objected, and plaintiff apologized at first, saying, "Oh, my bad," which is effectively an admission that she was doing what Cardi thought she was doing. Cardi testified that plaintiff wouldn't stop and just kept following her with her camera, with her phone out. Cardi testified that she was very concerned and nervous and confused by plaintiff's conduct. That is understandable. Cardi testified that she was concerned about her unborn child. Cardi referred to plaintiff as security heavy. She's a large woman. She's almost twice the size of Cardi. Cardi's pregnant, early in her pregnancy, and this person comes up to her in black boots and starts yelling at her. Cardi was concerned about her, and scared, frankly, about what she might do to her unborn baby. Cardi also testified she was confused. Why is this going on? Why is a security guard doing this? Why is she filming me? Why is she following me? Cardi also told plaintiff specifically that plaintiff was invading her privacy. But when Cardi told plaintiff to leave her alone, plaintiff went berserk. She yelled, it was plaintiff's phone. Plaintiff said, "That's my phone. This is my building. You can't tell me what to do."
You can use your
That's
eye.
what Cardi testified, and it's consistent with what Tierra Malcolm and Dr. Finke testified. But plaintiff advanced on Cardi, screaming and yelling and forcing Cardi backwards down to the hall to a corner, coming chest to chest with Cardi, yelling at Cardi about how, this is her building. She can do whatever she wants. Now, hearing the yelling, the doctor's receptionist, Tiara Malcolm, and then the doctor intervened and tried to get plaintiffs to stop and leave. We'll talk about that in a few minutes. In the meantime, Cardi testified that she and plaintiff yelled and used curse words, but neither struck the other. Cardi did not strike plaintiff. Plaintiff tried but did not strike Cardi. Cardi testified.
I don't want to interrupt. We're coming up on a break. If there's a logical place to stop, please.
Let him finish.
I can stop there if
break.
okay, let's.
All right. Well,
Weird.
stop there, folks. We're going to resume back at 1:30. In the meantime, please don't discuss the case with anyone, including other jurors. Don't form any opinions or do any research. We'll see you at 1:30.
That's weird. You're on a huge break. Oh, goodness. Okay. Do that one. Oops.
We're going to resume the defense closing argument.
Thank you.
Oh, yes, that is the worst. I forgot.
Good afternoon.
Weird.
We're back. So picking up where I left off, Cardi testified in this courtroom that the whole encounter was maybe 45 seconds, less than a minute. Counsel has urged, and I'll get back to this as well, that she didn't see what happened before, but if you add her and compare her estimates with those of Tiara and Dr. Finke, who said that it lasted about 45 seconds, it's clear that they came out right at the beginning. Now, Cardi also testified in front of you and under oath that she never spit on plaintiff. She never struck or cut plaintiff. She never touched plaintiff's face. She never used the N-word. She never threatened to get plaintiff fired. Cardi also testified that she is in fact left-handed, and we've talked already about how that undercuts Dr. Lanikin's theory that a right-handed person caused the claimed scar. Cardi testified that she didn't have any 3-inch nails at the time of this incident in February of 2018. She also testified that she was in Los Angeles. She lives back east, and she was in Los Angeles for the NBA All-Stars weekend in 2018. And we put into evidence a photograph of Cardi to prove that her fingernails were an inch or less. It's a photograph that she testified was taken at the NBA All-Star weekend. And you heard counsel earlier say that Cardi testified that photograph was taken on the same day of the alleged incident, on February 24th. That's absolutely untrue. She did not testify to that.
Those also don't look like
unclear,
3-inch nails
the
to
record
me.
can be read back to you, but I expect that you
those aren't
here
3
and
inches.
heard Cardi testify that she was here for a week or so and kept the same fingernails this entire time, and that includes February 24th. The assertion by counsel that she testified to something she did not, in fact, testify to is something that Your Honor that the judge had already indicated is something you should disregard. Now, she testified that the nails she was wearing while she was in Los Angeles were coffin square and not pointy. That was a new one on me. Apparently, coffin square means the shape and the square, and it can't cut anything. She also confirmed and testified that the rhinestone images were flat. They were not pointy, and they had no sharp edges. Apparently, you can get little rhinestones either as little decals on fingerprints or as rhinestones themselves. I'm not like Dr. Finke, a fingernail expert, so I won't talk about that. But the point is, rhinestones can appear on a fingernail, a decorated fingernail, either as three-dimensional or as flat, which, of course, flat can't cut anything. And she testified, as did Dr. Finke. Well, excuse me, I misspoke. She testified that they were flat. Dr. Finke,
fingernail guy,
counsel had said, testified that they were
weirdest
sharp.
Thing I've
He
ever
actually
learned
testified
about
he didn't know
witness.
whether they were sharp or flat. It is very important, actually, also that while plaintiff's testimony about what happened is uncorroborated, she called no witnesses who were actually there. Cardi actually did have 2 witnesses. And we'll get back to that. I do want to mention something that plaintiff's counsel raised, which is there's testimony from Cardi that as plaintiff advanced towards her swearing and pushing her back, that their chests touched. And counsel told you that that's an assault right there, that his client wins. Well, there's a couple of problems with that. Just touching chests like that is not an assault. And if it is an assault, it's an assault by plaintiff on Cardi. Cardi was being pushed back. That's the testimony from all both of the witnesses and Cardi herself. But I should mention, just in case you want to know, there is an instruction in the jury instructions that deals with the defense of self-defense. Counsel said that is inapplicable here because Cardi denies that she touched anyone or had to act in self-defense, or that she cut plaintiff. The point he's overlooking is that is up to you. You've heard the evidence. We think it's overwhelming that Cardi did not touch plaintiff at any point in time and did not touch this magic appearing, disappearing scar. But we have to be careful as lawyers. So we've included a defense of self-defense instruction, which means that if you were to find that Cardi did touch plaintiff, or that somehow a chest-to-chest caused by plaintiff is an assault by Cardi, which we dispute strongly, there is an instruction that the judge has given you that self-defense applies if a person reasonably believes that another person was going to harm her or him, and the person uses only the amount of force reasonably necessary for protection. I think there can be no doubt that Cardi was faced with someone bigger than her who was trying to hurt her. We know that from both Cardi's testimony, Tiara's testimony, Tiara Malcolm, and I believe also Dr. Finkel's. But let's talk about Ms. Malcolm. Tiara Malcolm, we called her as a witness, so we'll add her there. And she is one of the 4 people who are in the hallway, and she testified as an eyewitness, and she has no axe to grind. She's not a friend of plaintiff. She's not a friend of Cardi. She doesn't work for Cardi. They never met before. And so, again, she's an independent third-party witness. She testified that she was Dr. Finke's receptionist and expecting Cardi for a secret appointment. As a receptionist, she was near the front door. That's why she got out first before Dr. Finke, whose office was in the back. She testified it was a Saturday and all the other offices in the building were closed. And they closed early because, quote, they didn't want anyone there when Cardi arrived. When Ms. Malcolm, she testified that when she heard yelling, she immediately ran out. She's near the door. There's nothing she really could have missed once the yelling started. Defendant's counsel has argued that she wasn't there in the beginning, but we know from her testimony that she was near the door, immediately ran out when she heard yelling. Now we have a visual rendering based on plaintiff's own photograph of the hallway outside the doctor's office and based on the testimony and Cardi of Ms. Malcolm. This shows how far, you see the elevator bank and you see the doors that are depicted in the photograph that plaintiff's counsel showed you. And where did they end up? They ended up in that corner. That's how far this demonstrates, based on the testimony and evidence in this case, how far plaintiff forced Cardi B backwards and into the corner that Tiara Malcolm saw her when Tiara opened the door into the hallway. Ms. Malcolm specifically testified that when she opened the door, she saw that plaintiff had Cardi against the corner. Ms. Malcolm testified that she said, "What are you doing? You're at work. Go back to your post." And that the plaintiff just refused. She was going after Cardi. She was yelling, screaming. Ms. Malcolm testified that she got between them with Cardi behind her and with Ms. Malcolm facing plaintiff. The evidence is that at that point, Ms. Malcolm testified that plaintiff was swinging at Cardi, who was behind Ms. Malcolm. That's what she testified to. Now, Ms. Malcolm didn't realize at first that she was hit. She went after Dr. Finke came out and tried to deal with plaintiff, Ms. Malcolm took Cardi into the office, and someone else at the office, this is what she testified, Ms. Malcolm testified to, someone else at the office said, "What happened to your head?" That's when she found out. In all the brouhaha, she did not realize with Cardi behind her and plaintiff in front of her swinging away, Ms. Malcolm did not realize that she had been hit. Now, counsel told you in his opening statement that Ms. Malcolm didn't know she was hit. She knew she was hit. She went back to the office and she saw the scratch on her own head. Counsel has argued
Your Honor, I would object to him referring to counsel. We can talk about facts on counsel.
Plaintiff's counsel has argued to you that Ms. Malcolm didn't know who hit her. Okay, and he dwelled on that a lot in his cross-examination of Ms. Malcolm, and with all the things flying, with all of plaintiff's hands flying in the air, what Ms. Malcolm explained is her back was to Cardi. Ms. Malcolm specifically testified she did not see Cardi's hands go in front of her, go by Ms. Malcolm's head, but she did see plaintiff flailing away trying to get to Cardi. That's why she concludes that it was plaintiff who hit her. And it only makes sense. Cardi was behind Ms. Malcolm, and Ms. Malcolm was hit in the forehead, face to face with plaintiff. Again, I apologize for the language, but it's important that you hear this. Ms. Malcolm also heard plaintiff, who was almost double the size of Cardi, expressly threatened in no uncertain terms to harm Cardi. Quote, "I will F your shit up." That's what Tiara Malcolm testified to. She heard plaintiff threaten Cardi. That's an express threat. If anyone was being assaulted by threats of immediate offensive contact, it was Cardi who was being assaulted by plaintiff. Ms. Malcolm testified that while Cardi was behind her and Ms. Malcolm was face to face with plaintiff, Ms. Malcolm did not see any scratches or cuts on plaintiff's face, any blood on plaintiff's face, any injury at all on plaintiff's face, or any spit or spittle on plaintiff's face. Ms. Malcolm also testified that Dr. Finke came out of the office into the hallway and tried to get plaintiff to stop and wait. Ms. Malcolm then got Cardi into the doctor's office. She testified that throughout this, plaintiff had her phone in her hand. I want to repeat that since she testified here that she was using earphones. We've got another witness who says plaintiff was standing there, flailing away with her phone in her hand. Now, Ms. Malcolm also testified, and I know this gets a little bit repetitive, but it's important you remember this testimony and you take it into account when you deliberate. Ms. Malcolm also testified that Cardi did not hit plaintiff, that Cardi did not cut plaintiff with her fingernails, that Cardi did not use the N-word. Ms. Malcolm testified with Cardi behind her, almost touching her back. She did not see or feel Cardi swing at plaintiff. They didn't touch each other, although counsel asked, what about chest to chest? And Ms. Malcolm testified, which seems truthfully, when plaintiff had Cardi in a corner, Malcolm could not tell if their chests were touching. That's because she's behind them. She's coming out of the office door. Ms. Malcolm also testified that a few months later, plaintiff asked Ms. Malcolm to help her go after Cardi. Now, if you remember, counsel for plaintiff elicited testimony from plaintiff that she never really intended to sue Cardi. She never intended to go after Cardi. But that's not what Ms. Malcolm says. Ms. Plaintiff was trying to elicit witnesses to support a claim against Cardi. And Ms. Malcolm said, thank you, but no thank you. And she did that because she felt the plaintiff was at fault and, quote, she handled everything unprofessionally, close quote. Now, we also called Dr. Finke. He, too, was there the day of the incident, and he, too, has no axe to grind. He is not her regular doctor and never has been. He saw her that one occasion on February 24, 2018, when Cardi was here for work for the NBA All-Star Weekend and was concerned. She was pregnant, she wanted to see an obstetrician, and an appointment was made. He is a completely disinterested third-party witness with no axe to grind. Now, Dr. Finke, like Cardi and like Tierra Malcolm, testified that plaintiff, well, first of all, he testified his office was at the back of the suite. He heard yelling and he immediately ran to the front. Okay, so he gets there very quickly too. And he just has a little bit more distance to cover. And he testified, like Cardi and like Ms. Malcolm, that plaintiff had her cell phone in her hand. He saw plaintiff trying to hit Cardi. He saw poor Ms. Malcolm in the middle. And by the way, do you remember in the opening counsel for plaintiff said, well, Ms. Malcolm threw herself into the fight. If she gets hit, she gets hit. That's what happens when you try to help. I mean, really? I mean, she's a doctor's receptionist. She sees a patient coming there for a secret appointment, a pregnant patient. She tries to stop a security guard who's got the patient cornered in the hallway. And that's like, she asked for it? Is that really the answer? Dr. Finke also testified that Ms. Ellis had scratched plaintiff had scratched Malcolm's head. If you remember, the evidence is that Tierra Malcolm did not realize she was scratched until someone else in the office, the doctor's office, pointed it out. And also that Dr. Finke, once he got plaintiff to leave, which she refused to do, that he went back into the office. So he had a chance to see her at that point. That supports his testimony that he saw the scratch on Malcolm, not on plaintiff. Dr. Finke also testified that he told plaintiff, do your job, you're a security guard. But plaintiff kept yelling and she refused to leave. Kept yelling at them, kept yelling at Cardi. Now, while Dr. Finke tried to get plaintiff to leave, he was face to face with her. He testified they were within a foot of each other. And he testified he saw no cuts or scratches to plaintiff's face. He saw no blood on her face. Despite the fact that he testified that a cut on one's face bleeds more than a cut on any part of the body. This woman claims that she was cut in that encounter, but no one has testified that she had blood in her face. In fact, she testified she doesn't know if she had blood on her face from a scratch that has supposedly ruined her life. He also testified that he saw no spit or spittle on her. He also heard, he was there when plaintiff expressly threatened harm to Cardi by saying, I will F your S up. Now, Finke testified that Cardi did not spit on plaintiff or anyone else, did not take a swing at plaintiff, did not hit plaintiff, did not cut or scratch plaintiff, did not threaten to get plaintiff fired, did not use the N-word, and did not call plaintiff fat or poor. Dr. Finke also testified that once Cardi was safe in his office, he examined her in an examining room, and she did not have 3-inch fingernails. Now, in an interesting term, that was a surprise to me as well. He said he actually notices his patient's fingernails because it's a way of calming them down. It's a way of lightening the mood in the examination. So he's seen a lot of fingernails. And he looked at hers, and hers were not 3 inches. There were allegations, and you've heard little bits of it, that Cardi supposedly got plaintiff fired. Actually, Dr. Finke said it was him. He told his practice administrator, that this was outrageous, and based on the conduct he saw, plaintiff had to go. Cardi did not make a complaint. Cardi is not the reason that plaintiff got fired. Plaintiff is the reason that plaintiff got fired. Our evidence also included plaintiff's February 24, 2018 incident report. Plaintiff was asked in discovery, and we read some of that to you, which are formal written requests for documents or information, sworn under oath by plaintiff in this case. We asked for documents relating to the incident, emails relating to the incident. She never produced her incident report. We had to subpoena it from Ally. That's how we got it. We didn't get it from her. She claimed it didn't exist. Once again, common sense. There's something wrong there. We had to serve a subpoena on Allied, who produced a copy of the incident report, and we relied on that incident report because of plaintiff's inconsistencies and admissions. Now, it contains a lot of her accusations, and we believe the evidence is clear that they are false, but it also includes some interesting statements by plaintiff. And this is 2 days after the February 24, 2018 incident. Plaintiff, who testified, if you remember, that incident reports are very important. And she testified, and in the incident report, she told her supervisor that that Cardi had scratched plaintiff's nose. Not cheek, nose. 2 days after the incident, when she's blaming all of this on Cardi, which I think it's safe to assume that she was improperly doing so, given all the evidence we've heard. Plaintiff told her supervisor 2 days later, Cardi's with 3-inch nails, the evidence is against that as well, scratched plaintiff's nose. Nothing about a cheek. And again, a nose is not a cheek. They're different. This raises 2 points, really. Plaintiff's first statement that Cardi scratched her nose is directly contrary to plaintiff's sworn testimony here that Cardi scratched her cheek. Okay, so if we accept that, then the statement that she put in her report is clearly false, because she's now saying, and she's been saying for a couple of years, no, it wasn't my nose, it was my cheek. Second, plaintiff admits that her nose was not scratched. So this is a very important document because it confirms that she made false statements about the incident. At a minimum, she made the false statement that Cardi had scratched her nose. This statement, this incident report that she said is very important, also apologized to Allied and the building owner, quote, for behaving the way I did. Okay? Why would she apologize to them if she was attacked? Why is it something that she would apologize for? Again, common sense. She was apologizing because of the way she was behaving. She's apologizing to them for her professional misconduct. She's apologizing to them for attacking a medical patient who's trying to go in for a medical exam.
So you can wrap up in about 10 minutes.
Can I have a little bit of extra time since counsel got extra time?
I don't know that he did, but please try to wrap up.
Okay. I'm going to do this a little bit faster, and I apologize. We also called Nicole McKenzie. Nicole McKenzie is an interesting person because she's a psychologist, a workers' comp psychologist, and plaintiff called her too. It's baffling why he did, because all of her testimony only helped Cardi. First of all, no one called Dr. McKenzie as a psych witness. There were no psych witness questions. We called her because what plaintiff told Dr. McKenzie
right? Good morning,
in
Kelly.
April of 2018, just 2 months later, is directly contrary to what she's been saying. Ms. McKenna testified that let me rephrase this because I'm trying to cut some of this out. Ms. McKenzie, who you may remember, testified in this case that everything that she was saying was what plaintiff had told her. And she testified that when Dr. McKenzie did the evaluation, plaintiff made no mention of being scratched, cut, or even touched by Cardi. She actually said Cardi, quote, almost, close quote, touched her. Almost is not touching. Plaintiff has offered no explanation as to why she told Dr. McKenzie Cardi almost touched her. Ms. McKenzie also testified that in doing her evaluation, she would note any physical symptoms. And she confirmed that plaintiff identified no physical symptoms 2 months after she supposedly got cut in this incident. In response to one or more of the jurors' questions, the judge elicited the response from Dr. McKenzie that it was her standard practice that even if someone came to her just for a psychological examination, that she would also note any physical symptoms that were reported, and also that if she saw the patient and saw, if they've got a cut or scrape or a bruise or whatever, she'd note that as well in the report. And none of that was noted because none of it existed. We also asked plaintiff about her Kaiser medical records. At this point, I'll just mention that she testified and admitted that out of 161 pages of medical records over 2 years, there was no mention of any cuts, scratches, anxiety, PTSD, or anything else. Counsel noted that we called Dr. Rosenberg, who is a lifetime board-certified medical doctor who specializes in psychiatry. He has impeccable credentials and decades of experience. He, by the way, does not work on a lien basis. He does not work, we paid him, he does not work on a lien basis. So he doesn't have the same incentive that Dr. Mulliken has to spin his story. Dr. Rosenberg wasn't asked to diagnose any psychiatric conditions that plaintiff has. So in his report, he specifically said no diagnosis. But he did come to conclusions, okay, which is different than a diagnosis. And what he did was he had a 6-hour recorded interview of her, and he had her take a gold standard test of 335 questions. And what he learned from the test was that she claimed symptoms of different symptoms and so many symptoms that only 2 out of 1 billion people in the world have those symptoms.
I think it was 48, but
he also testified that there were inconsistencies with her story. We talked about the McKenzie analysis, in fact, that the plaintiff didn't mention any problems or physical injuries to Dr. McKenzie. We've talked about the initial incident report, which says a scratch on the nose, but not a scratch on the. So with all these different inconsistencies, that went into his analysis as well. Now, he also considered that in the Kaiser medical records, there's no indication of any of those injuries. And counsel, for some reason, focuses on vaginal discharge to say, well, if you're going for that, you're not going to mention a cut or scrape. But that's not what Dr. Rosenberg testified to. He testified that in April 2022, plaintiff went into Kaiser for a complete history and physical, and plaintiff specifically in questioning denied any kind of mental health issues, including anxiety or sleep problems. In April 2023, she went in again, and for hand pain that time, and she was specifically asked, Dr. Rosenberg said that's what Kaiser does. They ask you about everything, just noted in the records. And she was asked,
4 hours, Kelly.
again, reported no emotional problems
2.
and did not request mental health assistance. I should also mention this claim about PTSD. Dr. Rosenberg testified that you can't, quote unquote, an argument or an unpleasant interpersonal interaction isn't a trauma and can't lead to PTSD. The claim of PTSD is frankly an offense to those people who actually have it. She had a 45-second argument. She was fired. That is not what gives you post-traumatic stress syndrome. And we know that because we've heard it from a licensed psychiatrist who did all those tests and interviewed her for 6 hours. I should mention that Dr. Mulliken is a plastic surgeon. He's not a psychiatrist. So Dr. Mulliken couldn't and didn't rebut Dr. Rosenberg's conclusion that plaintiff is feigning. Counsel said, well, why didn't the defendants call a plastic surgeon expert? Because we don't see a scar. To call someone to say, can you examine this person? Do they have a scar? You can look at the photograph. Why would we call a plastic surgeon? Conversely, though, they want to prove that plaintiff had psychological injuries. Why didn't they call a psychiatrist? Let's talk a little bit about plaintiff's shifting stories. First of all, plaintiff alleges that Cardi spit on her. It's a disgusting allegation, of course, and I hate to even mention it. And Everyone else says it didn't happen. But for her part, plaintiff also hasn't gotten her story straight. If you remember, last Monday she testified in her February 26, 2018 incident report. Plaintiff told her supervisor that Cardi spit on her before people came out of the doctor's office. But at her deposition, plaintiff testified that Cardi spit on her after they came out. She can't get her story straight. That's that simple. Counsel has referred to spittle. And so what he's basically backed off of is initially it was a terrible spitting at her client. Now it's, well, maybe it was an accidental spittle. Say it, don't spray it kind of thing from junior high school. There's no evidence that happened, but it's also not an assault. It's also, when you look at the jury instructions, you'll see that an assault requires intentional conduct, intentional battery. Accidentally, spraying a little bit of spittle when you're arguing, that is not an assault.
I'm going to take my face down. I want to see his.
Plaintiff also is strikingly inconsistent regarding her claim that Cardi touched her. We'll go through this quickly. We talked about in the February 26, 2018 incident report. Supposedly Cardi scratched plaintiff's nose. In April of 2018, plaintiff told Dr. McKenzie that Cardi almost touched her. In sworn responses in discovery in this case, plaintiff stated under oath that Cardi viciously beat plaintiff about the head, face, and body. You haven't heard that, in this trial. No one said that occurred. In her deposition, plaintiff stated under oath that Cardi struck her on her nose and cheek, and plaintiff acted out Cardi jabbing plaintiff's face with an outstretched index finger, which is directly contrary to, and you saw that videotape of that, it's directly contrary to what Dr. Mulligan testified he thought happened.
Objection, Your Honor. We're going about over an hour now.
What's your objection?
That we agreed to 1 hour.
Okay, counsel, what's your wrap it up?
Can I have 3 minutes?
Just wrap it up.
Love that.
Okay. I'm sorry, there's more to talk about, but I've got to go. Ultimately, this case comes down to what happened in a minute in a medical building hallway. And to believe plaintiff, you would have to disbelieve Cardi, you would have to disbelieve Ms. Malcolm, you would have to disbelieve Dr. Finke, and you would have to ignore all of plaintiff's contradictory statements, including whether she had a cell phone, whether she had an earpiece, all that stuff. This is not a difficult case. It is not a close case. Plaintiff has the burden of proof, and the evidence is overwhelming in Cardi's favor. Plaintiff has not met her burden of proof. And plaintiff's demand for whether it's the $24 million that was testified to at trial or the $250,000 plus that you heard today makes no sense. She suffered no injury. Cardi did not do anything wrong except try to protect her baby and get to a doctor. The court will provide you with a verdict form, and we urge you that the evidence and common sense require that you answer questions 1 to 2 is no. That will skip you over to section B. We ask that you answer question 5 no. That will skip you over to section C. We ask that you answer question 8 no, which will skip you to section D. We ask that you answer question 12 no, which is then the end of the verdict, and you can have the foreperson sign it. I also want to note that for each of these questions, as the judge previously told you, 9 people do not have to agree. You can have 9 people agree on one, a different group of 9 people on another. And we ultimately, we thank you for your time, for your consideration, and you know how we wish you roll. So thank you.
I can't believe they both are talking and more about this.
Folks, as we indicated, plaintiff gets the first and last word, so time for a rebuttal case for plaintiff.
Oh, great. He's back.
Good afternoon. Thank you all for coming back. So this is the end of the road now. I said a lot of things this morning.
Breaks into a Boyz II Men
I
song.
want to repeat all of it. The main point that I want to highlight, which what counsel has brought up, is the incident report. In the incident report, Ms. Emani Ellis tells her supervisor that the defendant put her fingernail into her face. You will see that. Into her face and scratch her nose.
Maybe the cat was.
She caused damage to her face. It was a physical contact. As far as the spitting, I never brought up the word spittle. I don't know what that is exactly means, but in either event, Emani Ellis, who was there, who was a witness to this incident, testified that the defendant spit on her, actually spit on her, which is an assault and a battery. Everybody gets an attorney. Everyone gets to have an attorney. Even Cardi B gets to have an attorney. All of these comments and all of these things are smoke and mirrors to hide up the truth. Bottom line is, Miss Emani Ellis, who was there, testified multiple times. She never did anything wrong in her life. She was a model citizen, a good person. And she basically was doing her job as a security guard. And the defendant refused to cooperate, caused a disturbance, physically assaulted and battered her, spit on her, took a swing at her, and ultimately a couple of witnesses came after the fact, and they were not witnesses to the entire incident. The entire incident really took place between Emani Ellis and Cardi B, and it really is going to come down to, who do you believe? Who do you believe? Are you going to believe Emani Ellis, who was a security guard, who did her job, who was there, who never had any problems of any kind? Or are you going to listen to somebody who's yelling and screaming, has anger management problems?
Objection, Your Honor.
Got angry on that day. There's no question. She admitted it. She said she was angry. She got angry. She attacked the plaintiff. She spit on her. She used the N-word, disrespectful. She took a swing at her. She did everything possible to cause her so much emotional anguish and try to get a reaction out of her. I don't know how it was that Emani Ellis was able to contain herself, maybe because she is so peaceful. You heard lots and lots of testimony about how she was peaceful. The issue with Dr. Mulliken, at some point I did ask Dr. Mulliken, could this cut have been done by someone who's left-handed or right-handed? At the end, he was very clear. You can ask the testimony to be read back to you.
I mean,
He
I
said
think
it could be done by
a little
either a right-handed person or a left-handed person, either one. And when we had Cardi B on the stand, she said she was disabled because she was pregnant. But at the end of the day, she wasn't disabled with her hands. And you can cut someone with either hand, both hands. Go to the bench press, both hands. Anything can happen with both hands. This is not somebody who was taking a swing with a basket. In baseball, you must use the correct. No, this could be this injury could happen with the right hand or left hand, and Dr. Melka clarified that and said it could happen with either hand. Again, the evidence that needs to be brought forth needs to be proven by a preponderance of the evidence. We don't have to prove 100%. We have to prove a featherweight more than 50%. In this case, we have given you so much different evidence from different people, which was Emani Ellis, her grandmother, her mother, and all of the medical records. We have a plastic surgeon who came here and explained everything. You now have the case before you where you can now determine what you feel Emani Ellis should receive to make her whole. And counsel brought up some points to try to maybe muddy the waters in a sense and try to change what really happened here. At the end of the day, we have overwhelming evidence that Emani Ellis was assaulted and battered, and we thank you for your service.
I don't think his words mean.
All right, ladies and gentlemen, that
we know
concludes the presentation of evidence and argument. You're now going to be shown to the jury room. We do have a hard stop at 4:30. And by no means would I suggest that you should try and rush to be done by then. You do need to deliberate and consider all of the evidence before answering the questions on the jury form. And so if indeed it takes you longer than 4:30 today, then we will need to come back tomorrow.
Whether it doesn't.
If you want to take a break, you can take a break, but you all need to be back together in the jury room. So please do not deliberate until all of you are back together. To the extent that we do come back tomorrow, if you want to bring snacks or anything like that, that's fine. We can discuss that a little bit later. But for now, can I have Cynthia swear in Vanessa, please?
All right, we're not going to watch them get sworn in and go back. We're just going to skip right to verdict. That only happens. It looks like an hour. So let's fast forward to verdict. Snacks. I love snacks. I don't know if I saw, if you guys know who, what's his name? Tubby Nugget. Oh, I love Tubby Nugget so much. And Tubby Nugget has a song about snacks. And I was like, that's the theme song for Couch Court. But I can't play it because we'll probably get in trouble. But look up Tubby Nugget snacks. And I love it. Sam knows what I'm talking about. I think Sam is actually Tubby Nugget. I think that's her spirit animal. Brings me so much joy. Oh my God. I thought you guys said this is where the verdict is. I hear noises.
We're now joined by the members of our jury and alternate. And who is the foreperson? Do we have a foreperson? Number 3? Have you reached a verdict?
Yes.
Can you hand the verdict to the clerk, please?
Oh, thank you. Thank you, Dave, for the super chat. You got to keep this llama full of snacks. Thank you so much, Dave, for that. I appreciate you so much. Well, I wish we had a camera of like Emani's face when this happens, but I know.
All right, can the clerk please read the verdict?
Superior Court of the State of California for the County of Los Angeles, Emani Ellis, plaintiff, versus Belcalis Marlenes Almanzar, Cardi B, dose 1 through 50, inclusive defendant. Case number 20 STCV 07031. Verdict. We, the jury, in the above entitled case, answer the questions submitted to us as follows. Section A, assault and battery. Question 1. Did plaintiff Emani Ellis prove all of the following elements of battery? 1. Defendant Belcalis Marlenes Almanzar, Ms. Almanzar, touched Ms. Ellis in the intent to harm or offend Ms. Ellis. Number 2, Ms. Ellis did not consent to being touched. Number 3, Ms. Ellis was harmed or offended by Ms. Almanzar's conduct. And 4, a reasonable person in Ms. Ellis' situation would have been offended by the touching. Answer, no.
No.
Question 2, did Ms. Ellis prove all of the following elements of assault? Number 1, Ms. Almanzar acted with the intent to cause harmful or offensive contact with Ms. Ellis. Number 2, Ms. Ellis reasonably believed that she was about to be touched in a harmful or an offensive manner. Number 3, Ms. Ellis did not consent to Ms. Almanzar's conduct. Number 4, Ms. Ellis was harmed. And number 5, Ms. Almanzar's conduct was a substantial factor in causing Ms. Ellis's harm. Answer, no.
Nope. Mm-hmm.
Section B, intentional infliction of emotional distress. Question 5, did Ms. Ellis prove all of the following elements of intentional infliction of emotional distress? 1, Ms. Almanzar engaged in extreme and outrageous conduct beyond mere insults, threats, indignities, annoyances, hurt feelings, or other trivialities that a reasonable person is expected to endure. 2, Ms. Almanzar intended to cause Ms. Ellis emotional distress. Number 3, Ms. Ellis suffered severe emotional distress. And number 4, Ms. Almanzar's extreme and outrageous conduct was a substantial factor in causing Ms. Ellis to suffer severe emotional distress. Answer, no.
We're getting counters too, by the way. I should have known
Section
that.
C, negligence and contributory negligence.
She could have been a
Number
real
8,
B in
did
counters
Ms.
too.
Ellis prove all of the following elements of negligence? Number 1, Ms. Almanzar was negligent. Number 2, Ms. Almanzar's negligence caused Ms. Ellis to suffer physical harm rather than only emotional distress. And 3, Ms. Almanzar's negligence was a substantial factor in causing Ms. Ellis's harm. Answer, no. Section D, punitive damages. Question 12, did you answer question 4 and 7? Answer, no. Signed this date, September 2nd, 2025, by board person George Uloa, number 3.
All right, is it in which pull the jury?
No, you're not.
Nope,
All
we're
right, let me
good.
ask the foreman, was it unanimous as to all the questions?
Yes.
All right, so the question that the clerk is going to be asking is, was it unanimous as to all questions?
Question 1.
Or just all
They only
questions?
needed, what, like 9 people to
Was
agree
it unanimous?
Unanimous.
Yes.
for each one.
And then go through each of the jurors. Was it unanimous?
Was it unanimous, juror number 1?
Yes.
Number 2?
Yes.
Number 3?
Yes.
Number 4?
Yes.
Number 5?
Yes.
Number 6?
Yes.
Number 7?
Yes.
Number 8?
Yes.
Number 9?
Yes.
Number 10?
Yes.
11?
Yes.
12.
Yes.
All right, sounds like it was unanimous verdict as to all questions. Can the clerk please record the verdicts?
The verdict has been recorded, Your Honor.
All right, thank you. Ladies and gentlemen, thank you for your time and dedication to this case. I know that you've paid a great deal of attention throughout the matter, which was especially evidenced by the questions that you did submit. I want to thank you for that time and attention on behalf of myself, the parties, the court system, as well as the people of California. As I indicated before, this system does not work unless people like you are able and willing to serve.
Good job, Jerry.
I want to thank you once again.
Jerry got it
Throughout
right.
the trial, I have admonished you that you could not discuss the case with anyone, including other jurors. And at this point in time, I am relieving you from the admonition. You can speak with anyone about the case from this time forward.
Emani's not
I
invited.
suspect that there's going to be not only the parties that will want to speak with you, but I suspect also the members of the press are going to want to speak with you. And so I'm going to tell you this. I'm telling the members of the media this, and I'm telling the parties and their assistants that it's up to you whether or not you want to speak with anyone. If you don't want to speak with anyone, then you can just head right out the double doors, out the elevators. If there's press outside that want to speak with you, you can just walk past them. Don't let them stop you. If you do want to speak with them, then go ahead and you can wait outside the double doors. We're not going to be speaking with anyone in the courtroom. And if you do speak with someone, please be respectful of the views of any of your other jurors in terms of the deliberations. You can speak with respect to your point of view and how you saw the case. And the other admonition or the other issue with respect to speaking with people is that it's got to be at a reasonable time and place. And so if people start bothering you or if people reach out to you that's inconvenient for you and they continue to do so, let me know and I'll take care of it. Okay. All right. With that, once again, I want to thank you. You are now dismissed.
Again, 5 or 6:07. Okay, we got a brief presser afterwards, and then that's all we got today, guys. So let's see. Hold on. Sorry, that's too far.
Can you get my vinyl right here? Come in.
It's not very
Stand
long.
by, guys. Stand by. Party.
Okay. So first thing first, I want to thank my lawyers. I want to thank the jurors. I want to thank the judge, and I want to thank the respectful press. I really, really appreciate that, and I want to thank everybody at home supporting me. I know you guys having a little key with the moment, but to be honest with you, I have missed my kids' first day of school today. I missed my kids' last week of school yesterday because of this. And I'm not even playing around. I will, even if I'm in my deathbed, I swear to God, I will say it in my deathbed. I did not touch that woman. I did not touch that girl. I didn't lay my hands on that girl. And with that being said, this time around, I'm going to be nice. The next person to try to do a frivolous lawsuit against me, I'm going to countersue and I'm going to make you pay, because this is not okay. I think people have like this misinterpretations of celebrities, like it's like, oh, well, we can ask for this and they're going to settle. You don't work at home and you don't work all day and you don't work for your money to give out your money.
Mhm.
So don't ever think that I'm just going to give you my money that I work hard for. I don't lay in bed all day. I work all day. And I work hard for my money, for my kids, and for people I take care of. So don't you ever think that you're gonna sue me and I'm just gonna settle and just give me my money. It's not gonna happen.
Tell them, Cardi. Tell them,
I
Cardi.
do also want fans at home, though, not to find their social media, her family's social media, her social media, and bother her. I hope that this is something that I leave behind, that she leave behind. Don't go bother her. Don't be talking about her. Don't be talking about how she looks. Don't call her no nasty names.
Mhm.
Let's just put this behind, but I'm giving a warning. I am not that celeb that you're gonna sue and you think it's gonna settle. I'm not gonna settle,
Yep.
especially when I'm super completely innocent. I know I got a little reputation, but I swear to God I'm innocent. I swear to
We
God.
believe you, Cardi.
Like I'm really innocent for real.
We
And I
stand
just want to
with
say
you.
thank
We
you,
stand with you.
everybody. It's been really tough. It's been really long nights for me. I'm in the middle of album rollout, so it's been late nights
Am I the drama?
and early 5:30 in the morning. I gotta get up 5:30 so I can look like this for y'all.
I'm never getting up
Muchas
that early to look good
gracias,
for
muchas
people.
gracias para toda mi gente latina que me están soportando y vinieron toda la mañana. Ustedes se ven bien maquilladas, pelo, cuerpo bonito, y vinieron para acá para
5 días.
show me support. 5 días. Y los hombres también.
Una peluca diferente.
Una peluca diferente. I'm telling you guys, when I say that my forehead is raw from changing all these wigs, raw. And yeah, thank you for the witnesses and thank you for everybody that just took their time to come out. No.
They came back so quickly.
No, pero solo un warning para que no
It
tengan
says that it's bullshit.
De que cualquier persona que te vuelva a hacer algo así, que demandar, vas a contrademandar.
Voy a contrademandar, tú a ver. Si me joden otra vez, lo voy a contrademandar.
I think we're close to. Yeah.
By just telling the truth. It's really funny that people are just like, oh, she's amazing up here. I'm like, I'm just saying the truth. I'm just telling everything as much as detailed as I can remember. I'm just telling the truth. To be honest with you, like I didn't do nothing special.
Tus abogados hicieron un gran trabajo.
Sí.
Tus abogados hicieron un gran trabajo. ¿Cuál crees tú que fue la estrategia perfecta de ellos para contigo y ganar este caso?
Diciendo la verdad, siempre diciendo la verdad, tratando de tú sabes, el tiempo, las horas, investigando, tiene que investigar.
Por eso tú decidiste irte a un tribunal, ¿verdad? Porque
Sí.
sabías que era...
Ay, ¿tú piensas que es fácil darle a una gente tu dinero?
No,
Yo estoy trabajando. Una mierda. Ay, es fácil. Yo pensé que
Oye, Carlos, tus hijos, ¿cómo están?
they're good. I got two birthdays.
Cardi, what did this case take out of you? What did this case take out of you, Cardi?
Un saludo al gol de la placa. You guys are amazing.
You plan on celebrating your
I'll say this. I am very surprised. I didn't know anything about Cardi before.
Thank you guys for the. Thank you guys for this or my album.
Oye, Carmen, ¿cómo va a hacer algo con Yaila más real?
Sí, pronto.
Having that album, having this done, being able to move on.
It's a lot, but I'm ready to move forward. And please stop asking me about people you don't see. Let I know this right now.
You get that every day.
Thank you for the translation, lady.
Give us some space, guys, please. Thank you.
My Espanol
Give us some
is
space, guys.
no bueno.
Give us some space. Thank you.
Carly,
Watch your back. Watch your
I
back.
hate that stuff. Weak.
Jaws. Push them up a little bit forward. Thank you.
Back up, please. Back up. Back up.
Thank you very much.
Back up, please.
Cardi, we love you.
Back up.
Down with this way.
Back up. Back up.
Back up, back up.
Mis hijos quieren una foto contigo, por favor. ¿Dónde quedan? Donatio. Ven, 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 ven. Donatio.
She does not look very tall.
Allá están mis hijos, pero ya no los van a dejar.
How you like the court TV coverage?
Y vinieron para ver.
I know that
You got good angles of me.
but like
You got good angles.
Court TV angles was amazing.
probably wearing
Can I
nails.
get that on tape? Pop in.
Court TV, you had some good angles of me now.
Court TV.
Except for the first day.
I had you covered though.
Except for the first day.
I had you covered though.
Yes, you did.
I don't have this
Thank
fancy. Can you run the link
Thank
for me,
you.
please?
Let me go. I'm hot.
Take care, Courtney.
Thank you.
Start backing up, Emani.
Coming out, car coming out, guys. Thank you. Watch your back. Vehicle coming out.
All right, that's pretty much all that. We'll see if Ange can find the Emani video. I'll say this, as I was getting ready to say, is I don't know zippy zap about Cardi at all. Couldn't tell you anything better. I know of her name. I didn't even know what she looked like, to be quite honest. I wouldn't say that this made me a fan of her, but I do appreciate what she had to say at the end and how she handled. I feel like she was very classy in how she handled herself outside the courtroom after the verdict. You know, where did you post it at, Ange? I'm sorry. You know me, I lose things. You know, she could have filed a counterclaim against this woman, and she didn't, which is saying a lot. She gave a warning to others, which I thought was certainly called for, that she would countersue if anybody else did that again. And, you know, she did say, don't harass these people. Like, let's just be done with it, you know, because she probably knew that the internet was going to be coming for, and had been coming for Emani. So, you know, despite what you think of her, I do think she handled that very classy and very respectful. She did a great job with that presser there. And I don't feel like that was even, like, I felt like that was her response, not a curated one by her attorneys. And so I will give her mad props for that. Everything in the help. Oh, that's right. Thank you, Ange. See, I don't know what's going on at the time. Let's see. Which? Oh, there we go. Okay. Un momento, friends. So I don't know. I just like to give credit where credit is due. And I do feel like Cardi.
So first thing first, I want to thank my lawyer.
Hold on. Oh, this is like the whole of Cardi's. Oh, there's Emani. Okay. Okay.
Can we get a picture? High five.
Nope.
Not at all. I don't think that it reflects the truth, but I'm not disappointed. We know that the justice system is sometimes flawed, and unfortunately, that was the case for me. Like I said, I still stand firm on my position. I still stand firm on my attorney. I think we fought a good fight, but like I said, more importantly, it's about accountability. I had my day in court. I showed up. I held my head high, and I can walk away and say that I showed up, and she had to look me in the eye. I had to look her in the eye, and
okay,
we did our best.
Are you sorry you brought the case in retrospect?
Not at all. Not at all.
She said that she would refuse to countersue in this case. She said that if anybody else, brings a case, this is her words, that's frivolous, she called it, she would be countersuing, not to basically mess with her again. What do you think about that?
Don't worry, y'all. She's got another lawsuit going on for that car accident, remember?
Is, obviously, you never know what a jury's going to do. You could try a case in different courts with different juries, and you'll have 10 different outcomes. You just never really know what a jury's going to do. We did our best to present the facts that we needed to present to the jury, and we obviously have a right to appeal, and our intention is to appeal.
You're going to appeal. How do you feel about how the defendant conducted herself in court?
I thought it was totally unprofessional. I think it showed
volume to her character, the type of person that she is. A lot of her
Wow.
body language, her body gestures, her facial expressions, her disrespect for the court, I think speaks to who she is. I think we saw how I conducted myself during this trial, and I think that speaks volume.
Sir, could you say and spell your first name and last name?
Sure. My name is Ron Rosenjanfaza. I'm the attorney for the plaintiff. I've had this case for a number of years. I did take it over from another lawyer, and we put it together as best we could with what we had to work with. I disagree with the verdict. As you
Cardi
know,
said nothing bad about her.
From Cardi B, she has a history of doing these things. Even today in the courthouse, right in where I'm standing in this area, she threw something at one of you. And I think that's just, very poor judgment on her part to go ahead and do something like that here in the courthouse. This is a court. You don't do this. It's wrong. And she really, made a fool of herself, in my opinion.
With a unanimous verdict, what is the basis for an appeal? Would it be a factual error, something that the judge did wrong? What would the basis be?
What would it be?
Well, there's many different things that occurred. I can't really get into the details now. That would be for the appellate attorney that I work with, who's going to be handling that with me, and we will decide how we're going to handle it.
Ms. Ellis, what's next for you?
I'm going to law school.
Shut up. This case prompted you to decide to go to law school?
I had already had plans on going to law school, but I think during this case, it kind of amplified a lot of those dreams.
Do you feel like you've been painted in a bad light in the public?
I think from the defendant, yes. But that's what she's going to do. She's going to make me seem like a bad person. I know who I am. I know the things that I've accomplished. So that's all that matters to me.
You started out as a fan of her music. Are you still a fan today?
No.
Will you be listening to her new album? It drops in 6 days. She keeps saying.
Not at all.
Ms. Ellis, Cardi did ask that the public please leave you alone, not slander you, say things behind your back on social media. Does that mean anything to you?
That's news to me. She's never told me that. She's never even offered me an apology. So I'm not sure.
Oh, you guys. Oh, I'm so glad we watched that. What? She's going to go to law school now? What, she get tips from her fucking lawyer? Get out of here. Oh my God. What world do those people live in? That's mind-blowing to me. How not classy are they? Oh my gosh. Wow. She will not be going to Disneyland, but she's going to law school. I mean, maybe her lawyer got like a degree online or something. I don't know. Probably. All right, the marker one. Hold on. Let me. Oh, this must be it. Okay, hold on. I gotta download it first. Okay. And come back over here. Wow. That was just, I can't even. Oh, she does, doesn't she? Oh my God. She's never given me an apology. She didn't do nothing. You don't get an apology unless you do something to somebody. So, and sorry, babes, it didn't happen. Didn't happen at all. Hold on. I'm a mess over here. I don't know what I'm doing. Oh my gosh. Oh, me too. Me too, Lady in Gray. Oh my God. I can't. That's going to be in my mind all day. Like an hour from now, I'm just going to still be ranting about it. All right, let's see. This happened after lunch the same day, apparently.
All right.
Hey, Cardi, you're beautiful.
Thank you.
Cardi, insiders are claiming that Offset is publicly bragging about getting you pregnant for the fourth time. Do you foresee any paternity issues with Stephon Diggs?
Stop disrespecting me. Don't disrespect me. How you feeling?
Cardi, your court look is amazing. Who are you wearing? Cardi, I still love you even though you just threw some stuff at me.
I don't care. You're disrespectful. Don't do that. Do you see women asking those type of questions to me? Do you see women asking those questions to me?
It's legit.
Why do you feel as a man you got to ask me those type of questions? Act like you have some manners. And your mama taught you, respect women.
Good.
I mean, I ain't even that upset about it.
Can somebody hand me my marker?
Good. Fuck that guy. She does always throw stuff. I mean, she didn't try to make herself in the presser sound like, she's this fucking angel or anything, you know? She admitted she does get spicy and whatnot, but this wasn't one of those times. So, well, that was she threw a mic at a crowd. I mean, I don't know. Sorry, Emani, you didn't have a strong case, babe, at all. Like, at all. At all. Well, you guys, that is the wrap up. Oh, wait, hold on. I got to do my little gavel thing because we just finished it. Oh, I got to get better at remembering that. Oh, here we go. Court case closed for Cardi B versus Emani Ellis. Well, that trial was something. You know, no wonder Emani thinks she could go to law school with that fucking lawyer she has. She's like, damn, anybody really can go to law school, apparently, and pass the bar. Don't throw that gavel. Well, you know, I am known for throwing things. Yeah, thank you. That was fun. That was a fun short trial. Civil trials are something else. They really are. You know, you really can file anything in a civil case. It doesn't mean it'll go to trial, but you can. Like I've seen, there is a show I thought about doing in the future, which was all about ridiculous civil suits. Like there's somewhere like people have tried to sue the devil. There was a prisoner who tried to sue his own self and blamed his own self of why he was in prison. It's very bizarre. I've seen one about a house that was haunted, and like these people bought this house or whatever, which was a well-known like haunted house, right? A crime house or whatever. And then they move in and they didn't realize how many people are like obsessed with this house, and they did not win their lawsuit. It was very interesting though. I know there was another one because civil suits can be about anything, right? There's this one where this lady passed away, right? So there was like her estate, and I want to say she gave all of her money, which was a lot of money, I believe, to some charities, because a ghost told her to, and her kids were pissed about it because she gave it away from a ghost. So yeah, there's all sorts of crazy lawsuits out there. And then there's other ones like that people, you know, this is what pisses me off though about the frivolous ones, is like it takes away from cases that are more legit, because now everyone is always skeptical when they're in a lawsuit or watching a lawsuit. You know what I mean? Like you already have this feeling that like something, you know, grubby happened and there's money involved and, you know, all of that. But yeah, there's some crazy ones. There's that kid in was it the 90s? I think it was, when they had those Pepsi points, and you would like collect points for all sorts of things, and then you would get prizes. And they were giving, I believe Pepsi was giving away a jet, an actual jet, if you collected 1 million points or something like that. And this kid, this like 10 or 12-year-old, collected all the points for this plane, for this jet. And Pepsi was not planning on paying out because they didn't think it was possible for some reason. I still don't understand. And the jet is like $5 or $20 million. I don't know. I've not read about it for a long time. So feel free to go look it up yourself, because maybe only half my stuff is factual. That's just my memory there. But so then they like do a lawsuit, and Pepsi is like ordered because they didn't want money at all. All right. This kid wanted that jet. It's great. Maybe we'll cover that sometime, do like a lawsuit compilation or something, because it's crazy. That would be fun to cover just for laughs, because I mean, some of them are outrageous. Lenny says, oh my God, I watched a video on Long Crime, I think last night, where an Air Force guy caught his soon-to-be ex-wife poisoning his coffee. Oh, They were living in Germany at the time, and he had to wait, oh my goodness, until they were back in the US to bring all the evidence he collected. That's interesting. I'll have to look into that. Angie says, keep your eyes out for us possibly streaming a marathon in Discord soon. Yeah. We're making plans to stream Lost. It's not true crime related, but it's fun. It's a mystery show. I love it. And we're going to do some marathons. It's a big ask, okay? But that's probably where we're going to be spending a lot of time in our Discord watching that. So if you haven't yet, join our Discord server. It's where we all hang out when we're not live. So come hang out with us this weekend. We're probably going to watch some Lost. So come hang out. It'll be a good time. Now, next week, you guys, because while we were listening to that, I did some checking around, and the trial that I was looking into covering, of course, as always, it has now been moved to November. So that's fun. That's so fun. I love that for us. Actually, that's fine. I don't have anything on the schedule for November. I didn't really find much. So hopefully we'll do Apodaca in November. But what that means for Couch Court is we're going to have a really light week this week with Couch Court, because I have a lot of stuff I really just need to catch up on. And so Monday, I'm not exactly sure what time yet, so make sure to have your notifications on. It'll be in the morning. We're going to do some reading of Chad Daybell's letters from death row that he's now making public to tell his side of the story and why everyone is wrong. So that's going to be fun. So come make fun of Chad Dumbbell, because I'll tell you what, it is something. And then we have Midday Missing, and then our launch party. And that means Wednesday, though, we will be doing the sentencing of Brooks Houck and Joseph Lawson. So I think that's at 2:30 Eastern on Wednesday. So we'll still have stuff going on, but we're not going to do a trial this week. We got little things we need to catch up on here and there going on in the regions. We hang out chatting until 4 a.m. Sunday. Were you guys up until 4? Oh my goodness. That was late for me too. Party animals. You're right, late and great. Anytime we get a mock Chad Daybell is a good time. Y'all, he is. Love that for us. Oh, you were? Oh, you party animals. Well, you guys, I'm going to take a quick break. If you guys are members of our channel, I will be live in about an hour at 2:00 for members only, where I'm going to be recording parts 6 and 7 of The Devil in the Bay, my new investigative miniseries that'll be released in December. But members, you get a sneak peek and get to be there to watch as I mess up names, re-say sentences over and over again. It's a good time. So I'll be doing that for a few hours this afternoon, and then I won't see you all till Monday, unless you come hang out in our Discord, which you should do. And if you don't understand how to do it, it's fine. Just ask. Everybody there is so nice and helpful. But you guys, that is all I got for you today. Happy Friday. Hope you all have a wonderful, amazing weekend. Amazing weekend, even. Just thought of that. All right. And burp cam. Yes, Lady Gray. There will probably be burps. There's always burps. All right, you guys, you have a great weekend. And as always, go forth and be amazing. Bye, guys.